Withdrawal. Okay.
Tomorrow,
Day after.
Lordship. And I have a prayer, item number 20. That matter has been enforced, so I want to withdraw.
Your name?
SI Akan.
S.I. Akand, the learned counsel appearing on behalf of the petitioner submits that the requisition. The N. Busami appears on behalf of the government of Assam. And Mr. A. Butcher appears on behalf of. Into account the above, the instant with closed has become infructuous in terms of the instance vacated.
Please, your Lordship. I beg to pray before listing the matter for admission, Lordship.
Okay, Friday.
Prayer for withdrawal. Friday.
Friday, withdrawal.
Please, your Lordship. I beg to pray for listing of the matter in admission manner.
Friday.
Hello.
I beg to mention item number 99 and 100 from supplementary.
99? Any matters are there? Okay, 99, what do you have to say?
Your Lordship, on last date on 17/7, they have respondent number 3 have filed their affidavit. So kindly grant
Look
us-
into it later.
I beg to mention item number 41 of the daily list. I may not like to take up this matter.
Okay, I can't take it up. It's the matter before any other bench.
Okay, madam.
Number 1 for withdrawal.
Same.
Comply.
Why do you want to withdraw?
And order has been complied. Your Lordship.
Mr. S.I. Akand, the learned counsel appearing on behalf of the petitioner submits that the order dated 7/6/2023 passed in WPC number 5316 of 22 has already been complied with. Mr. A. Butcherji appears on behalf of the respondent. Taking into account the above, the instant contempt proceedings stands closed.
96, item number 96.
Please, your Lordship. I have an instruction to withdraw this writ petition.
B. Ghosh appearing on behalf of the petitioner submits that she has instructions to withdraw the instant petition. Accordingly, the petition stands closed. Well, interim order, if any, stands vacated.
Deeply.
$97 for withdrawal.
I have instruction to withdraw it, my lord. The liberty, my lord.
What liberty?
So we are, the DC has assured us that he will do the needful, my lord. That's why we have to withdraw it, my lord.
This case about?
This is my lord land, this thing.
Huh?
My lord, the apportionment of compensation, my lord, because the compensation that is, we own a 24 bighas of land. Out of that, the compensation amount is to be divided, my lord, me among other legal heirs, my lord. But it was not proceeding according to our this thing, my lord. Now DC has assured that we will do the
Witness. Have any difficulty go to before the reference court? No liberty. The learned counsel, Mr. J. Roy, the learned counsel appearing on behalf of senior counsel appearing on behalf of the petitioner submits that taking into account that the relief, that taking into account that the petitioner, if so agree, would be at liberty to approach the appropriate court, taking reference, if agree with the apportionment of the amount, he would not like to press the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal.
Right.
So it is, however, made clear that the withdrawal of the instant writ petition shall not preclude the petitioner to approach the appropriate forum if so otherwise advised.
All right.
Item number 2 for motion.
Please, Lordship. Lordship, we have already communicated to department regarding the status of the verification.
Complied?
No, we have not been compliant, Lordship. We are already waiting for the instruction. On last occasion, we are just requested by the court to make the necessary whether verification has been done or not.
Kamsar Ali.
Tamsir Ali, as per
Yeah,
Tamsir.
then what happened? Have you
We were,
verified it?
We have communicated with the department. By Wednesday, I'll take up the instruction, Lordship. We have already communicated. By Wednesday, they'll give us whether verification has been done or not, Your Lordship.
You verify and put it in the list. That's it.
That's it, Your Lordship. But the honorable court says whether verification has been done or not, that was the instruction we have to take.
Eviction not done.
For my section is concerned, not done.
And you were given long time on the last occasion.
So you are not
Friday.
Friday, Your Lordship.
Mr. R.R. Gogoi, the learned counsel appearing on behalf of the PHC, submits that he would obtain the instruction as to whether the petitioner entitlement has been considered in terms with Tamsir Ali or not, in terms with the judgment, in terms with the judgment of the full bench in the case of Tamsir Ali versus State of Assam and others reported in 2008, 4 GLT, page 1. Who's the list the matter again on Friday. Friday did to be.
Obliged, Lord.
Number 3.
Look, in this case, the lordship passed an order
Hmm.
for allotment of water. That is basic service to the urban field.
Hmm.
The lordship passed an order. Here, the lordship directed the municipal authority to hand over the water constructed by the to us within 60 days. So far, the other 2 cases are 3 cases were filed here. So far, other 2 cases are concerned. Your lordship directed to consider their
Your case was which one? Which writ petition?
P185 of 2019.
What is the direction in respect to
Paragraph
P185?
page number 22. Last. As regard the petition number WBC, as the said petition have already been deposited their amount, and only reason why the position have not been handed over is on account of the pendency of the Eastern writ petition, which stands culminated with the passing of the Eastern judgment and the order. The respondent authorities are directed to hand over the position of the flats to the petitioners, WBC number, at earlier, not later than 60 days. Order was passed on 3/10/2020.
Just making it returnable on where's the GMC council? No GMC. Yes, Mr. Naik. Why this has not been complied with? Your only submission made on that day when the matter was taken up is that on account of the pendency of the repetition, you are not in a position to comply. That was the reason why.
Or should we wait for some time, Lordship? In the meantime, I'll inform.
Just ask him to come. Mr. Naik, ask him to come at 2 and ask him to get that instruction. You give a copy to Mr. Bora. What is this?
Compensation, my lord, page 37, my lord. By order dated, my lord, 21st of January 2020. An amount of, my lord, 1,25,000 has been then as an interim.
125.
compensation, my lord.
बाकी की नहीं दिया।
So you got 125.
Yes.
And how much do you want?
My lord, as per notification, we entitled 5 lakhs.
Oh,
But
And-
they have given my lord 1,25,000.
Lordships, as per my instructions, the DLSA has written to us saying that they have issued notice to the applicant several times. And there's no, at the address which is with the DLSA, the applicant is not available, your Lordships. Prospective claims. Question is-
7 तारीख में 3 तारीख.
question is-
हाँ.
question is जाने तो या तो DLSA तुम्हें तो
yes, why you are not going there?
My lord, as per my instruction, my lord, 137. The petitioner was appeared and her statement was recorded.
Very well. Then they will look into it.
Yes, my lord.
They will look into
And-
it, nothing.
And the similarly situated matter, my lord, already disposed of by your lordship. my lord.
Absolutely no. Court is not to look into all these aspects of the matter. If you are not getting anything, then we will look into it.
Yes.
They are trying their best to get you, trace you out. They have not been able to trace out. The petitioner herein has filed the instance with petition being aggrieved by non-payment of the amount of rupees 3,75,000. The remaining amount of rupees 3,75,000, which the petitioner claims to be entitled to in view of the scheme, in view of the
victim
Assam
compensation scheme.
Victim Compensation Scheme 2012. Full stop. This court, by an order dated 19/6/2024, had sought for instructions from the Legal Service State Legal Service Authority as to why the petitioner have only been paid 1,25,000 out of the 5 lakhs. Full stop. Ms. R.S. Chaudhary, the learned counsel appearing on behalf of the State Legal Services Authority, has placed before this court an instruction dated 21/6/2024, issued by the Secretary, District Legal Services Authority, wherein it has been duly mentioned that on coming to learn that the petitioner is further entitled to an amount of rupees 3,75,000, various attempts were made to trace out the petitioner, but the petitioner could not be traced out. Later on, it has also it's also mentioned in the said instructions that the learned counsel appearing on behalf of the petitioner could be contacted. Mr. M.H. Hussain, the learned counsel appearing on behalf of the petitioner, submits that thereupon the petitioner had duly appeared before the District Legal Services Authority on 3/7/2024.
Notice dated, my lord,
It's okay.
21/6/2024.
3/7/2024. So taking into account that the Legal Service Authority is in session of the matter, this court is not inclined to entertain the instant petition at this stage. However, it is made clear that if the petitioner is aggrieved by the non-payment of any amount, after a reasonable period of time, the petitioner would be at liberty to approach. The instructions so submitted by Mrs. R. Chaudhary, the learned counsel appearing on behalf of the Legal Service Authority, is kept on record and marked with the letter X.
At least, my lord, time frame has been given.
Reasonable. Absolutely unreasonable. Reasonable.
1 month or 2 months, my lord, maybe.
Reasonable.
Lordships, may kindly, just one word, Lordships, the DLSA is in session of the matter. The DLSA, the District Legal Service is in session
The
of the matter.
DLSA.
Deeply obliged, Your Lordships.
God bless.
Yeah. नहीं ना वो उन्हें mention withdrawal का नहीं Hmm.
But the petitioner found bank account has been to hold and thereafter freezed, my lord.
Huh?
Bank account of the petitioner form, my lord, was initially put on hold for an amount of 5 lakhs and thereafter it has been freezed. It has been done purportedly for the, on the ground of criminal investigation of 2 cases, my lord. One registered in Telangana and other, my lord, in Jhansi, Uttar Pradesh. On query being made by the petitioner firm, they were saying the 3 transactions, my lord, made on 8th of March and 10th of March of 2023 are the transactions, my lord, because of which the bank account has been freezed. My lord, on these 3 transactions were made, where the payment has been received in the bank account of the petitioner, my lord, on because of sale of 4 vehicles to 2 persons, one person at Telangana and 1 person at Tamil Nadu, 2 persons, and the payment has been made by 1 person called Joseph. He belongs to Mizoram. This person, and because of these transactions, my lord, the account has been freezed, and they were being told by the investigating authority, my lord, that this Joseph is involved in some fraudulent transactions in FIR, my lord, lodged in Telangana and Jhansi, my lord, says, my lord, from their bank account, my lord, some amount has been fraudulently taken off. By that is unknown, my lord, who have taken off. The bank account of this petition has been freezed because Joseph has paid amount for the sale of vehicles, my lord. But if we take your lawsuit to page 37, my lord.
What do you want now?
So we may be allowed to operate, my lord, the bank account, my lord, in terms of 103, my lord, CRPC, my lord. There it says, my lord, by giving an indemnity bond, that what item seized can be handed over to the persons from whom seized, my lord. But these
We do one thing, we issue a short notice, making it next week. Okay? So, oh, the other 2 officer in charge, how do you serve them?
If I may suggest, my lord, the public prosecutor Assam, they may contact, they probably could have. Government of Assam also may check online. Provide the scan copies of the.
Your entire bank account has been
Fine.
freezed. Thereby your business has been stopped.
So they have 1 more bank account. By that account, they have been going to now.
So you're running it through another bank account. So then you are running something.
Somewhere, but major amount is in this account. My lord.
How much? Where is the money? This is the bank statement at page 30.
Yes, sir. But
How much money you are having?
that doesn't contain the.
As on 11th of March 2023, you were having only 63,000. Is this the bank account?
Because the initially the amount of my lord, 5 lakhs was put on hold.
Where is the money? How much you are having in the bank account?
Currently, my lord, that part is not available.
Yeah. Your difficulty has to be seen. Where is that order by which it has been freezed?
Page 43, my lord.
We regret for your convenience caused in operation of your account. Please, as per the direction received from the Cyber Police Station, Jhansi, Uttar Pradesh in FIR number Iman, please contact the investigating agency for the needful. This was given in the on the month of September, March 2024. Thereafter, you contacted them.
They contacted my lord. I have stated
Then what happened? After you contacted,
they were being told, my lord, because of these three transactions, my lord, if I may.
where have you mentioned out here that you contacted after March 2024?
My lord. Page 13, my lord, paragraph 11.
You are having a business out here. How are you selling it out there to Tamil Nadu?
Context, my lord, the people
How? How? It is not allowed. What car you are selling?
only. My lord, we
How?
deal in all sort of used car vehicles, my lord.
Huh?
Used car vehicles.
Used car.
Used car vehicles.
How much amount is there in your account?
I'm being told, my lord, at present, my lord, an amount of my lord 23 lakhs is.
So 23 lakhs is the amount of belonging to that Joseph fellow. Kindly see paragraph 11. 10 lakhs, 7 lakhs, and 18 lakhs. So it is more than that, 35 lakhs, and you are having 23 lakhs. Okay, very well, rightly seized. Put another 12 lakhs.
My lord, you kindly see the transactions, my lord, page 30 onwards, my lord.
Now page 11, page 13. This is the amount you say has been deposited in your account. So that is 35 lakhs. You are having 23 lakhs. So put another 12 lakhs. And get the,
Usually, my lord,
we may open the freezing of the account to that extent of for you to deposit the remaining 12 lakhs. You want that?
the transactions, my lord, they were being put on hold initially for an amount of 5 lakhs.
But you say at paragraph 11 of your petition,
My lord, will you kindly see, my lord, page 33.
page 33 shows only 42 for 63,000 is your balance.
No, page 33, my lord, annex 3.
Yes, that is it. How much you are having in mouth? Page 32.
That is in the month of March 2023. my lord.
Understood. 18 lakhs, 7 lakhs, and then another 5 lakhs somewhere. 10 lakhs.
10 lakhs.
So
On
these are the
8th
two things which you have done.
This
8th
amount
of
has been
March, 8th of March, 8th of March, and
10 lakhs.
10th of March.
8th of March, 8th of March, and 10th of March.
So these are yeah. So 35 lakhs, and you are having only 63,000. So what is there? You should be happy only.
Well, this is of 11th of March 2023, my lord.
What happened now? How much you are having now?
Around 23.
So if something happens, if these are proceeds of the crime, then
As CRPC 103, my lord, provides, my lord, that if an indemnity bond is being executed, my lord, then the amount seized can be article seized can be handed over to the person.
indemnity bond of what? Of the entire amount.
Entire amount, my lord, what is available. in
So
the
that is 35 lakhs. It is 35 lakhs. Then let's issue notice. We can't issue a short notice now. With these people of a party. Issue notice making it returnable on 2nd of September 2024. The petitioner is directed to take steps upon the respond numbers 1 to 4 by way of registered as well as usual. In addition to that, the petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court. Stop. And file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the freezing of the bank account of the petitioner bearing number
350-428-41162.
0-350-481-841-162 page 30 লেখা আছে on account of certain informations on account of directions issued by the respondent number 3 and 4. It is seen from a perusal of the petition that the said direction has been issued on account of the deposit of an amount of rupees 10 lakhs, 7.7 lakh 20,000 and 18 lakh 70,000 to the bank account of the petitioner by one Sri Joseph Keswan it's spelling whole KEISUANKHUALA for purchasing of 4 vehicles. The respondents shall on or before the returnable date file their affidavit as regards their stand, bringing on record their stand.
I pray for a date in the middle of August, madam.
How can you serve? I would have understood the State Bank. How do you serve the other two?
The office of the public prosecutor. Can it be through the office of the public prosecutor?
No, nothing doing. In fact, you should have made the state of Telangana and state of Uttar Pradesh a party. You know, how can you make some officials a party without making the state? Because anything he has done is against the state. Anyway, we can have it in on 27th of August, 28th of August. Today is what date? 22nd. Okay, 21st of August.
I'm deeply obliged.
For 6.
Yes, what is this?
By this petition, I am challenging a notification matter whereby the time limit prescribed for orders are extended matter. Similar matters are fixed today in a series matter. It is listed today.
Take it up together.
I'm saying that in the
We
meantime.
dispose of all the matters together today itself.
In the meantime, GST Council has made some recommendation, my lord. In the meantime, my lord, GST councils have made some recommendation. And budget is scheduled tomorrow, budget, my lord. So there is every possibility that this matter may become infructuous, my lord. It's not taken up after a week, my lord, because tomorrow is the budget schedule. These are the recommendations, my lord. My lord.
Announcements have been made in the third GST Council meeting.
That is there, my lord.
The government has announced that without payment of interest and penalty, taxpayers will be able to pay the tax and they will be discharged of all the liabilities. One is that announcement. There is a second announcement. All the liabilities related to section 16(4) input tax credit, because the returns were not filed by the SSCs in time. Government has announced that they will extend the time limit before which the returns were filed, and all of the petitioners will get relief. And the budget is scheduled tomorrow, Lordship. Might be some 1 week, Lordship grants us time. Maybe all of the petitions will not require any adjudication.
We'll have it on Friday. It's this matter along with the other matters, no? Item number?
I have ordered list, my lord.
We will give the list to the court.
44 to 74.
44 to 92, Lordship.
44 to 92. 44 to 92. We listed all these matters, we listed together on the 26/7.
My lord. And item number 42 and 84, 91 are interim order still today, my lord. No extended.
Nothing is going to happen. The government is in your favor.
Other matters, my lord, interims are until further orders, my lord. Only in other matters, my lord.
No, heavens will fall. We'll have it on Monday, on Friday.
My lord.
It will.
Matters are not similar, I will inform the court master.
Huh?
Matters are not similar.
Which are not.
40 and
40, we are not concerned. We are only from 44.
74.
74 is what? 74 to 80 বেলেগ কে উলাই লৈ ল'ব, huh? Baki khini, all these things be listed again on 26th. It has been submitted at the bar by the learned counsel appearing on behalf of the petitioners for the batch of writ petitions that that there is a likelihood that some announcement may be made tomorrow in the budget session, and as such, which may impact the writ petitions, the outcome of the writ petitions. Taking into account the above, the instant batch of writ petitions are directed to be listed on 26/7/2024. A2 item number A2, to just write it like that. List this matter on 26/7/2024.
Deeply obligated.
Seven.
74 to বেলেগ দি। Yes, what is this?
This case, my lord, the petitioner hearing was imputed as the respondent, my lord. In a-
FC criminal case, what is this? What
in
are
that
these
case,
matters?
my lord, I have been made as the respondent, my lord, whereby respondent number 3 hearing, she has filed a petition, my lord, claiming maintenance from me, projecting myself as her husband, my lord. But
Huh?
in fact,
Maintenance before whom?
my lord, the family court, my lord, Kamrup Metro.
And you are not getting a copy.
I'm not getting a copy.
Where is your application?
My lord, I applied for the certified copy. I could not annex the same because, my lord, I already submitted it before respondent number 2, my lord.
Huh?
So I submitted it before respondent number 2, my lord.
Who is your response number 2?
Respondent number 2 is the superintendent, my lord, of the family court, my lord. He is the authority to furnish copies, etc., my lord. Your lordship will find that paragraph 6 of my petition, my lord, page number 6. My lord. I have stated here. I never received any notice from the court, my lord.
And it is fixed for which arguments?
No, my lord.
What is this?
Your lordship will find
At page 15?
it was earlier, my lord, because the main petition, my lord, that has been disposed, my lord, expertly, my lord. And
Which
then
one?
subsequently, my lord, execution proceeding has been initiated, my lord.
Ah,
So I never received any notice from my lord, the court, either in respect of the main family petition claiming maintenance, my lord, as well as the execution, my lord. So therefore, I could not enter appearance and the matter has been, my lord,
now
decided.
you are asking for certified copy.
Yes.
And you have not received it.
Yes,
That's it.
yes,
Chalo, we dispose it of.
my lord.
Directing without prejudice to, on the basis of this orders, you shall not be entitled to claim that this court had duly accepted that it was proceeded ex parte without giving you a copy. The instant with which he heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. A. Bachchaji appears on behalf of the respondent number 1.
Why one, I do not know.
Why 1? What is this? Why you make him a party?
Because, my lord, the
What
matter,
does the revenue have to do? No business of revenue. Anyways,
Right.
your name is there. The fees out there. Appears for the respondent number 1. Mr. N. Goswami appears for the respondent number 2. The instant petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent number 2 in furnishing the certified copy of the application filed by the respondent number 3 for maintenance, which have been registered as FCCRL 718/2019, as well as also the execution application, which have been registered and numbered as XEX bracket CRL 70/2022. This court is of the opinion that if the petitioner had applied for the certified copies of those documents, of those applications which have been duly filed before the court, the petitioner ought to have been granted a copy. Without, however, expressing anything on the merits, this court directs the respondent number 2 to forfeit and not later than 5 days from the date of submission of a certified copy of the instant order, supply copies of the certified copies of the application registered as FCCRL 718/2019 and applications, copies of that registered as so and so, and EXCRL 70/2022. It is, however, made clear that the order passed herein shall not in any manner be understood that this court have duly had expressed any opinion as regards the ex parte proceedings decided and pending before the learned family court.
Obligation.
Here is a lot.
Yes, what is this?
My lord, one of the bank account lying in the petitioner's bank is suspected to be involved in money laundering case, my lord. And accordingly, my lord, the Jodhpur police station as well as the enforcement directorate has directed the writ petitioner to mark debit freeze of the account.
Too much?
To mark the debit freeze of the account.
Okay.
Accordingly, my lord, the petitioner's bank has put the account under debit freeze. Now, subsequently, my lord, while the debit freeze is continuing, the respondent number 1 and 2, that is the enforcement directorate, has directed us to release the amount involved in the bank account. To release the amount in their favor by way of demand draft, which is at page number 223 at annexed 6 and 9, my lord.
Page 2?
223 annexer 6, my lord. Paragraph number 3, in excess of the power conferred upon me under subsection 4 of section 8 of the PMLA Act 2000, you are hereby directed to make demand draft of the frozen amount along with the interest accrued thereon favoring so and so joint director enforcement duty, my lord.
Okay, then.
And my lord, we have replied by annexure 8 at page number 227 that the amount is already under debit freeze under the instruction of the Jodhpur police station as well as the other department of the enforcement directorate, and we requested the ED to take NOC from the other department.
Okay, then.
But without listening to our request, my lord, by annexure 9 at page number 229, the enforcement director has once again directed us to deposit the amount lying in the bank account, my lord.
And what is this? There is an order passed?
Yes, my lord. In the similar case, your lordship has passed order at page number 235. Whereby the bank is allowed it to keep the amount lying in the account, my lord.
Where is the union? We have not served copies? Why nobody is appearing?
Has been appear, my lord. Not name, but
Who appears for the enforcement directorate? And this is Rajasthan. Officer in charge of Rajasthan.
station, he has directed us, my lord, to mark the debit fees of the particular bank account.
And there is another, which other that there is also another by the.
Yes, my lord. Right, annexed to the respondent number 2. He has also directed us to mark the debit fees.
It is
And
by another area of the. Where is that annexure?
annexed to at page number 29, my lord.
This is by another one.
Yes, my lord. The 3 authorities. Now, one of them wants to get that.
This is by the Guwahati zone.
Yes,
This is
my
by the
lord.
Guwahati zone.
Guwahati.
And this direction is being given by the.
Enforcement Directorate, Guwahati Zonal Office, my lord.
No, the last direction.
Last direction, page number 3, annexed 3 at page number 31, my lord.
No, page 223 is by the.
Page 223 is also.
This is also by the Guwahati.
Yes, my lord.
This is by the Dimapur subzone. And this is by the Guwahati zonal.
Yes.
And this is in connection with another case.
Same subject matter, my lord.
Is it another case?
Yes. The order passed by your lordship in connection with another case. Similar matter, my lord.
Which is presently pending.
Yes, my lord.
Get hold of Mr. Arcade Chudi. Pick it up after some time. Call him. Because he is the one who is repairing.
Number 9. 9 and 11 are also similar to the series, my lord. We have taken up on Friday, 9 and 11. Oblige, your lordship.
And number 10.
Lordship, in an identical matter, filed by the same petitioner against the same respondents, Lordship has already issued notice. May I pray for issuance of the notice?
That came in bench 4. Why this is coming in bench 5? That matter pertaining to some amount we are to get after the amount.
Lordship, this is a matter where we are saying that the FCI authorities should have invoked the particular clause 26.6, whereby duty is cast upon them to ensure the workability of the rate prior to acceptance of the tender.
Who is appearing for the government? And
I am for Transport Department, Section 9. I am formal party. FCI is the minister. I'm
okay, same order hobo. Kale naam to bodli lo. K Gogoi instead of that, Mr. N Goswami.
FCA, my lord.
You are for?
FC
No, for state of Assam. Who appears for the standing counsel for respond number 228?
Me,
You are.
I'm appearing on behalf of my senior BK Singh, my lord.
BK Singh or SK Singh? BK Singh. BK Singh. BK Singh hoga.
Written BK Singh.
Okay, SK Singh will laha.
BK Singh.
Oh no, your name is SK Singh.
No, my name is D. Pegu.
There was another.
I'm appearing on the behalf of my senior, my lord, BK Singh, standing counsel of FCI.
He is not around.
No, he's out of station, my lord.
Your name is?
D. Pegu. D. Pegu.
D. Pegu. Standing counsel on behalf of respondent number 228, MD Bora for respondent number 9, and Mr. N. Goswami for respondent number 1. Oh no, who appears for union? Esbolua. Where is she? She was here, na? Esbolua for Union of India. Learned CGC appears on behalf of On deep, we go for respond number 228.
228.
MD Bora for respond number 9.
Both these matters. can-
11-9, we have fixed it.
Also, both these matters can be taken up together.
It's okay. Fixing it on the same date. I can't take it today.
Okay.
Well,
Yes, what is this?
Actually, this is a case, Lordship. I am a, my lord, the holder of a, my lord, a commercial truck, my lord. So this was placed with the respondent number for transportation of my lord vertical LPG cylinder from the LPG bottling plant in Silchar, my lord. Then the IOCL used this truck, my lord.
Huh?
This Indian Oil Corporation has used this truck, my lord. They are allowing us to, my lord, load the LPG cylinders for the purpose. And this are going on since 15/6/2024 till my lord. From 16/6/2021, they are all on a sudden that was stopped by the IOCL authority. They are not allowing us, my lord. So we asked for the reason. No reason was assigned as such, my lord. We verbally asked for. So we also, my lord, also, my lord, inform the respondent number 4 here, my lord, under whom we are working. There is no response from there also. Since 16/6/2024, our stock is, my lord, lying idle in the IOCL bottling plant at Silchar, my lord. So that has been taken on higher purchase, my lord. We have to pay around 43 or 45,000 per month as EMI, my lord. So you are unable to pay, my lord. They are neither releasing nor, my lord, they are allowing us to. So this, let them obtain an instruction as to
Where
why,
is it
my
that
lord.
you have asked for release of the vehicle?
My lord.
Where is your notice, application, representation submitted that you have sought for release of the vehicle?
I did not submit, my lord.
Best way is to come to the High Court.
I asked for, my lord, that they should inform us as to the reason, my lord. If reason is granted on basis.
Show
of
me
the-
under what, where you have been, your car, vehicle was taken by way of some acceptance or some.
My lord will,
contract was-
yes, that my lord will find it pays, my lord, at page 20, my lord. Page 20, lordship. Letter of acceptance. My lord,
Yeah, Iman transportation of Indian so
Yes.
and so. This is given to Abida Sultana.
yes, my lord.
Who is he?
He is the respondent, he is the main contactor, my lord.
Who are you?
My lord, I have placed my trust through him to IOCL, my lord.
Who him? You
Yes.
take the money from him.
But IOCL.
You have an agreement with somebody
Yes,
A.
yes, yes, my lord.
That A has an agreement with IOCL. IOCL does not accept A's some trust. You are
They
to
have
get the
accepted my
money.
trust, my
You
lord.
take the money from
They have
IOCL.
accepted my trust, my lord. They are allowing us to, my lord,
It is not allowing you,
Ah.
allowing respond number 4.
but my truck is, my lord, lying idle. They
Take the
are-
vehicle back from the
my
respond
lord.
number 4. Get that vehicle back. You have an agreement with the respond number 4.
Yes, yes. Agreement, there is no such agreement, my lord.
What is your agreement?
Agreement was made with the, my lord. I have just offered to place a truck.
No. What was your agreement with the respond number 4?
Yes,
There has to be some agreement.
Such agreement, my lord. Actually, they offered us to place our truck to them, my lord.
You had nothing to do with IOCL.
That I understand, my lord. But
You
my,
have an agreement with
Yes,
the
that I
respond number
understand.
4. What is your agreement?
my agreement with respondent number, my lord, that we have placed a truck with him, my lord. But
What is your agreement? The agreement cannot be beyond consideration. You must be having a consideration. What is your consideration?
I'll consider that they will pay us against the, my lord. the
Who will
truck
pay
they
you?
take.
Who will pay you?
Actually, respondent 4 will pay me, of course,
So,
my lord.
respond number 4 happy.
But
Get the
thing
money
is-
from respond number
My
4.
lord, thing is that, but the problem is this, my lord, the truck is not, not
How
yet.
do
Why
you
they have to
involve, Mr. Bose, how do you involve the respond number 4? The IOCL. IOCL has no business with you.
Yes, I shall not business with
Get
you,
the
my lord.
vehicle,
That's true.
you get the vehicle from respondent number 4.
At
Or
least, my lord,
you ask the respondent number 4 of the vehicle, or if you are not
but
getting
the-
any money,
Actually, my lord, when the truck is
you have
placed,
to get the money from the respondent
my
number
lord,
4.
when the truck is generally placed with the IOCL, they are the authority to, oh, my lord, they allow or disallow, my lord, under the custody of the IOCL, my lord.
How? Where? Show me.
My lord, that is lordship page 20, my lord will show. That is the acceptance. They have accepted the truck for the purpose of loading.
Which
Lordship-
truck?
Yes, my
Number?
lord. AS 11 DC 9033. That is my truck.
Where?
My lord, that is 1, 2, 3. My lord, last two but one, my lord will find. In page 20.
Page 20.
Yes, my lord. That is the letter of acceptance.
Basement of which,
Yes.
which vehicle?
AS 11 DC
The
9033.
various aspects of it shall be subject to the decision in the case. Is letter of acceptance, which vehicle?
AS 01 DC 9033. That is my vehicle.
And 033.
Yes, my lord. No, it is there under their custody, my lord.
How do we know that it is under their custody?
That the my lord can obtain instruction, my
If
lord.
they have not sent you the truck, how is it relevant? We have an agreement. Why is that person not coming? That person not coming if his vehicle is not being taken. He is not getting the money.
Well, in that
Do
way,
you
I am
get the money directly from the IOCL?
in that way, I am suffering, my lord.
No, Mr. Ghosh, do you get the money directly from the IOCL?
No, my lord, I don't get.
So you get the money from somebody else. So you get the money from him.
But my truck is not
How
lying
can it
idle
relevant?
there because under their custody.
Where, what were you doing with the truck?
I have approached the respondent 4 also. They are not responding also.
So it is a dispute between you and the respondent number 4. And you are involving the IOCL and filing a writ.
But at least they should, my lord.
They, I mean, very good mood. I'll issue a notice.
Lordship.
Nothing more than that.
Yes.
Only notice.
Lordship.
Okay. Heard Mr. B.J. Ghosh, the learned counsel appearing on behalf of the petitioner, is making it returnable 6th of September 2024. The petitioner is shall take steps upon the response by registered as well as usual. In addition to that, within 3 days, the petition. In addition to that, the petitioner is also steps by way of the steel routed through the registry of this court and this court, although have issued notice, however, keeps the maintainability of the writ petition open as to whether the instant writ petition be at all maintainable against the respondent IOCL's. Where is Mr. R.K. Dev Chaudhary?
It's in another court, lordship, for a enforcement directorate, their own counsel is there. They have own counsel.
Who?
Standing counsel is there for enforcement directorate.
Who is that?
Notice up to court, I don't know lordship about that.
No, all along Mr. R.K. Dev Chaudhary is appearing or Miss A. Gayan is appearing. Get hold of any of it. Any of both. Any of the persons you get hold of. Or ask Mr. R.K. Dev Chaudhary to appear. We'll see. Because there is, you see, madam, there is another matter, connected matter, where there is an interim order passed. You see, there is one which is done by the, in respect to the same person against whom money laundering proceedings are going on. One action is taken by the, what do you call this person, what's his name? By the Guwahati office, and another action is taken by the Nagaland office. This is the Nagaland office matter. Okay. So here they have asked for. Now the question is, when there are two authorities taking up the same thing of the same department, that is why I want the enforcement director, and Mr. R.K. Dev Chaudhary is appearing in that matter. Get hold of it. Yes, what is this matter about?
Biddings are more or less complete. It's now for final disposal.
Yes, disposal. Argue.
Hello, this is the second round of litigation so far these parties are concerned. Earlier, there was a direction from the lead court, then that matter went on appeal. So far, the direction of the lead court was concerned by the London Civil.
What is the matter about?
It is in regard to a construction of a building where the height of the building is now being disputed because as per the order of the learned single judge, it cannot exceed 11.5 meters. That is the only issue. And we have, because whatever was excessing of 11.5, we have complied with it. But the building permission was obtained on 2014 and the construction activity continued. And when the petition was filed by the opposite party, ultimately the finding of the court is that the height of the building cannot exceed 11.5 because the boundary margin was only 1 feet. If it was 1 meter, if it was more than 1 meter, 1.5 in Tinsukia municipal board, then it could have been 11.5, more than 11.5. Now the problem is that all this was regulated by the 2014 rules that was prevalent at that point of time. And that has also been reflected in the order of the learned single judge. And ultimately we went on appeal, but the appellate court did not interfere. That is one. Second is, as per the now a new.
You are the petitioner in which petition?
1212.
You are dial construction.
Dial construction. So 1212, your lordship will first see the order of the learned single judge.
What are you asking for?
Yes, madam. Relief.
Direct the respondent authorities, more particularly respondent, to cause an on-site physical verification of the building in question standing on the plot of land measuring Spencer under Tinskani in order to ascertain the height and head used to the permissible limit of it.
We are seeking only now.
So you are only asking for a physical verification.
Physical. Now the problem what they have created is that 2014 rules when it was in vogue and.
And what was the single judge's order?
Yes, the single judge order starts from page 26. And the relevant portion your lordship will find at page 36. Paragraph 13.
Interferes with the building permission, renewal permission made in favor of Gayatri Devi Chaudhary. Who is Gayatri Devi Chaudhary?
The petitioner's side, madam.
Huh? Petitioner who? Petitioner name is some Dial Chaudhary. MS Dial Construction. Who is Gayatri Devi Chaudhary?
Who was the mother of the petitioner who has in the meantime expired and the legal eyes have taken.
The same can be constructed to be a valid only to the extent of 11.5 meters. So 11.5.
Yes.
Then what happened? You went to the division bench.
We complied with the order.
You went to the division bench.
Yes.
And division bench did not find any error.
Yes, sir. That order is at page
Then
38.
Tinsukia Municipality passed an order at page 53.
Yes, sir.
So as you know, the deviation that has been occurred in the assessment of the building. Then what happened?
But we complied with the orders of the court 11.5. Now
It is found to be 7 inch more than the permissible 11.5 or so and so. This is the field verification report.
Yes. Now your lordship will see from an
7 inch will be this much.
Page 64.
Okay.
Page 64 and
I have started dismantling the extra portion above the. Then
page 65, next page, madam.
21/1/2023 with reference to the by demolition the excess height of the month. So it has only 7 inch. 7 inch.
Now page 66 also your lordship will see.
Now, construction is what? Well, under the 11.5, we have constructed a septic tank. And we have also art filling work we have done. We have not raised the height of the building. And lift and staircase is being covered. This is a commercial building, and because of this litigation, my lord, I have not been able to complete.
Then what, another writ petition filed?
Then your lordship will find the order.
Section 9.
Then the private respondent approached this honorable court, my lord.
For what?
Your lordship will kindly see.
The order passed.
Order at page 71 of WPC number.
Is this the second writ petition?
Yes, your lordship will find the order at page 71.
You got it.
In 11th portion.
Then no construction.
So, my lord, what they are doing, my lord, after even of the compliance, my lord, I have told only, I have made the septic tank and all that is within the, inside the building, not raising the height. But they come and threaten every now and then. And that's why we approach this
Only
honorable court.
issue is as regards the height.
Only the height.
And if you are constructing inside, what do they have to say? Yes, Mr. Datta.
Absolutely, the entire petition based on a false statement, my lord. So for the height is concerned, so for the petitioner is concerned, that I have to like to first address. Now the permission was obtained in the name of the Gayatri Devi, who happens to be the mother, husband and mother of the other respondent in the deed application. Now this present deed application has been filed by Messrs. Doyle Construction. He is neither a party to that deed application. He is one of the party in the deed appeal. But all other who happens to be inherited the Gayatri Devi Chaudhary, there may not be made in parties. This is the first point. Second is that after closing of the everything, by this deed application, they again reopen the entire matter.
Reopen what?
In the deed application, in the earlier round of first, the deed petition disposed by the single judge. In paragraph 6 of that judgment, it has been clearly held that admittedly the height of the disputed building is 12.94.
But there was a field verification carried out.
Now thereafter, they filed the REIT appeal. In the REIT appeal, they themselves say by their own architecture certificate and also in the pleadings in the REIT appeal that the height is as per their statement that 12.35. And thereafter, after the disposal of the REIT appeal, they filed a review application. Only on this basis, that on the issue of the height. And in the review application also, that the Honorable Division Bench held that the height is 12.94.
12.94.
And that was disposed on 7/3/2022. Now,
what is this field verification?
Now, they said in their REIT application, this present in paragraph 7, that there was an order of the review during the pendency of the review application on 28th of January. On 20th of January 2022, asks for a field verification. But we have annexed the order of 28th of January 2022. There was no order. So there was a collusion in between this REIT petition hearing and also some official of the municipal board. And that was also clarified their own affidavit. Now their own affidavit says that there was no demolition. Because Lordship kindly appreciate that they have casting the roof up to the second floor. Now the second floor, Lordship may kindly appreciate that the height of the roof casting, that is maximum 5 inch. And we annex the construction permission of the petitioner, wherein the roof was shown to be a 5 meter. 5 inch of the roof casting. Now, if it happens to be 12.94, then the entire roof will go. Even if it is 11.7, then also the roof will go. Because the permissible limit is 11.5. Now roof is as on today intake, and they made a false statement before this honorable court and thereby obtain a interim stay that they have complied the order of the learned single judge. And therefore the contempt is still pending. So that if they demolished and complied with the order of the learned single judge, the entire second floor will go.
Let's see the review order.
Yes. Lordship will find in our affidavit in opposition at, kindly have a look at page 124, the judgment, the learned single judge judgment.
124.
Yes. The relevant property is 131. Para 6, Lordship can say. 131. It is not disputed on this date. RCC building has been constructed up to height of 12.94. That was not disputed. How could now they say it is 11.7 or 11.6? And now, Lordship, kindly have a look. Page 143, that is the order of the learned Honorable Division Bench in writ appeal. 143.
Which portion?
Lordship will kindly have a look at page 157. Last concluding plot. Paragraph 17. Admitted position with regard to the extent to the construction made beyond 11.5 in height.
Okay.
Now, interestingly, Lordship, in the writ appeal, they filed and certificate by their own architecture. Lordship, kindly have a look at page 142 with annex that. That was annexed at Annexure A in the writ appeal. That was dated 28th of May 2018 by one Mr. Arup Gogoi.
12.35.
Yes, he has certified their own that from the road level it is 12.35.
They measured the building of the height and found the height of the building not from the road level or from
the road
existing
level.
Road level. Okay.
Now, Lordship kindly appreciate that after closure of the review petition, they come up with this. Then thereafter, the municipality issued a notice. Though the single bench has directed the municipality to demolish, not the private respondent. But instead of that, municipality asked them to demolish, just shifting the duty. And at one point in the contempt petition, the municipality says that due to the hammer and etc., they could not demolish it. Now the private respondent now come up with a statement before this honorable court that they have demolished. They have complied the order. The Lordship kindly have a look, the affidavit in opposition filed by the municipality.
No, where does the review? Where is the review?
Yes,
order?
kindly have a look at page 182. Relevant parties, page 187.
Even in our writ petition also, we have annexed the review order. 1212 is at page 54.
I'm relying upon my affidavit in opposition. Let me complete.
Okay, which relevant portion?
Page 188. The page one.
Height of the but the construction was raised up to 12.94. Was hence dismissed.
Yes.
Oh yeah.
They came up with a story that during the pendency of the review application, this measurement was done. But that measurement, that communication, that survey of the municipality, that was not placed before the review petition and before the devotion bench. That was not placed. That was not part of the record.
What does the municipality say? Who is appearing for the municipality?
Lordship, kindly.
Mr. S.S. Roy is appearing because of some personal involvement.
None appears for the Tinsukia municipality. Are you appearing or not?
On behalf of Mr. S.S. Roy.
No, on behalf of. You appear for Tinsukia municipality or no? No, on behalf of. How did you sign a wakalatnama in your favor? Then either you appear on behalf of Tinsukia municipality or will say that none appears. Then What do they say? Okay, Tinsukia municipality, what do they say?
Now, interestingly, Lordship kindly appreciate that the survey report that was annexed with this writ application, that is not communicated with them. And this is the official communication. And how they could obtain all those official communication, and that was objected by the municipality in their affidavit in opposition. Page 218.
What did they say?
218. They said that they have visited the site and made some observation. Only out of 4 members, only 2 has signed. Paragraph 8. But they also question that how could this writ petitioner got these official documents? (218) Lordship kindly have the last part of the paragraph. Then Lordship kindly comes to paragraph 13 and 14.
What do they say?
13 and 14, they say that on just before the writ application is filed, they have inspected and found that there was no demolition. There was no complaints of the learning single judge order.
Page?
Page 220, paragraph 13. It is further denied that the petitioner reduced the height of the building up to 11.5 meters. Answering respondent for the submit.
And as per 11.5 meters should be from where?
Lordship?
From the ground level, from road level.
From the level of the building. From the level of the building. And it is on apparent face of the records, the learning single judge has came to findings that it comes to, as per their drawings, is 12.94. That is the 12.94 touches the second floor custom. Already the ground floor, first floor, second floor custom. Now the casting is 5 inch. Now without demolishing, without cut short this second floor, that compliance of the learning single judge order does not arrive at all. Absolutely false statement.
How do you calculate the 11.5 meters?
As per the drawing.
It should be from the side of the building. Here, the main problem is they have calculated it from the middle of the road.
How could this can be raised?
They said from the center of the road.
We are not measuring.
The height regulation and all, what we are seeing, madam, we want to give it.
That makes a difference.
Yes, madam. Your lordship is rising, madam.
But the height has to be
Yes.
from a particular where the height has to be calculated.
Oh,
It is
lordship
given
is
in
high.
54, my lord. Height regulation is there.
Therefore, the architecture certificate of there,
Yeah.
from road level, there he has
Road
taken.
level, we have given it, my lord. What we are seeking today is a re-verification. If we have exceeded 11.5, as he wants it, that municipality to demolish it, let it demolish. Rule 54, clause 7B will be applicable so far we are concerned. Second line.
It was,
7B will be applicable so far we are concerned. 7B, rule 54, then small Roman 7, then small capital, small p. We have a parking space, madam. In case of parking space, it is 2.7 meters, that relaxation will be there also. and ours is 2.74, we'll get a relaxation of only 2.7.
So you have the parking.
The parking, ours is 2.74, so we'll have this only, we'll
They're
get
having a basement parking,
2.7.
basement parking, not there.
Yes.
Basement will not come.
For a building constructed on the stilt with the provision of ground level parking or semi-basement parking floor.
Ours is ground level
The
parking.
height of the building shall be calculated by omitting the height of the parking floor up to a maximum of 2.7 meters. The purpose of the building height subject to the provisions.
That is respect of lordship in the ground floor parking.
Yes, we have a ground floor parking.
This is a basement parking, lordship. We have annexed the construction permission.
Ground.
Where is the construction permission?
Lordship will find. In our
The
affidavit.
permission has never been interfered by this honorable court, madam.
Let's see, where is
That
the
has already
permission?
been lapsed.
Huh?
Page 32 of the writ petition, 36 of the writ petition
Show
number
me, one of
390.
you, show me what it is. Where is it? This is it, at page 115.
113.
115.
That is not the map,
Your
that is the permission.
application is
113.
demand. Battery
That's from
decree,
113.
I've storied.
Ground plus 4.
So G plus 4.
Without side plan. Without side plan.
Now, has this been interfered with?
No, only
No,
the
only up
writ
to
code
11.5.
only. Therefore, the cut size, the building height is to 11.5.
11.5.
11.5 is only for 3-storied.
What would be, the code said 11.5.
At the time of construction, only it was stopped.
It, at the time of construction only it was stopped.
11.5, that is the second floor.
Permission was.
Now,
up
if
to
it is,
4.
if they are giving for 4-storied,
Yes. But this code
dismantling
regulated
the
the height
existing
only.
80 building and dispose and propose RCC commercial building for Gayatri so-and-so under the land of so-and-so. Total area 7.2 Iman. Basement parking 4,000, ground floor 4,000 Iman.
And during the construction, we have done only up to the second floor only. Then only the code regulated the height up to 11.5.
How?
Since they approached, my lord, that
Side setback.
by filing a writ petition, they approached this honorable. court.
Understood why? Because here it
Yes.
would amount to interfering with this because it was ground
we
plus
have
4.
left the side width of the building as only 1 meter.
Huh?
Only
Less than
1 meter width we have left.
2.5.
As per rule 67 of this act, if it is 1 meter, then 11.5. If it was 1.5, then we could have gone beyond that.
67.
67.
Sub rule 3.
So therefore, they interfered with this thing. The single judge has interfered with the building plan.
Only modified.
Modified,
Not
interfered,
Yes.
because it was ground plus 4.
Yes.
So now you are given ground plus 2.
Yes.
Now you have the basement. So from the basement, it has to be 11.5. No, not from the basement, the casting of the basement,
Yes.
is it 11.5?
Yes.
That's it, nothing more than
No,
that.
no, that's why we are seeking a re-verification. If you find that it is the height is more, you demolish it.
And who are you? No, wait, who are you?
I am the neighbor. Therefore, I am the lead petitioner. That maintainability issue already decided by the learned single judge in our favor.
No, we are still going to decide. This is a fresh petition. Now tell me,
I am
11.4.
not
Don't worry with that.
challenging the judiciary.
11.4. It has to be from the casting of, from the floor of the basement.
The building, as per the, I am not expert, but as
So
far
where
the
the-
architecture is concerned, their view is that the building height has to be from the road level.
No, it can't be from the road level. You see, if we apply, just for example, if it is a semi-basement, if you see 67 Roman 7 B, then they add 2.5, 2.7. They may not get that because it is basement. So it has to be from the basement, the floor of the basement, above the basement. From there, it can't be more than 11.5.
Yes.
That's all. We'll direct the measurement to be carried out within the 1 week. They let us give it. Else they-
Because we have a doubt on the integrity and of the municipality, that the PW department will also join, because earlier the municipality asked the PW department to help them.
But the problem is, Malad, your lordship will specifically direct to do it in terms of Rule 54. Otherwise, they are always create havoc.
No, I'll make it very clear.
Yes.
You see,
Yes.
you have a basement parking.
Yes.
From the top of the basement parking, which will be the floor.
Yes.
It has to be, it can't be more than 11.5. And if it is more than that, to submit a report within 10 days. Where is the PWD? PWD, anybody? I'm coming back. And if that is being done, to demolish matter.
Yes.
Why should we go into all these things?
Yes,
And by that, the matter, huh?
No, we should not.
Because if you see 54(7)(b), it makes it very clear that if it is semi basement, then they will be given 2.7 meters, semi basement. But if it is the basement, then it has to be on the basis of the floor of the.
Lordship may at best can say that 2014 rules may be followed.
No, I'll make it clear to that effect. Because I'll make it from the floor or the
Yes.
from what do you say?
Basement floor, basement roof casting.
From the basement roof casting, it will be 11.5 meters. Huh?
They in the last 4 years they diluted the entire
Who is
matter.
suffering the loss? Our
No,
commercial
from
building, you have to say.
11.5 from the basement roof casting.
Yes. Top of
Correct.
what?
And PWD be taken into consideration.
Get hold of a PWD council, I'm coming.
So propose a small proposal. Well, since PWD is not a party, an advocate commissioner can also go, will bear the cost equally of the advocate commissioner, your lordship appoints it.
Not necessarily. We cannot. PWD will have the VA. Okay. let me- How does the BD want to learn its new council?
Before that, I just take an indulgence. Lordship, we must just clarify, nothing, we are not expert. 7 says, for the purpose of height calculation, width of the road shall be taken into as existing road width. Now, the width of the road, that's includes A to C. So for the calculation of the width, because it starts from 7. So the prefix of this ABC is, for the purpose of height calculation, width of the road shall be taken to the existing width. Then ABC.
No, this has been made in view of the fact that it has to be, it can't be more than 1.5 times the width of the road. See, nowadays we don't have it out there.
We say that the parking floor should not be beyond 2.7 meters.
So if there is a parking or a ground floor or a semi-basement parking, you can take the height at best to 2.7.
Now, you say this parking is absolutely basement parking.
Understood. So from the basement parking, it cannot be more than 11.5.
But
We are not giving him the advantage of 2.7. We are not giving him
No,
the
that's
advantage.
correct.
We are giving him the advantage only
Suppose for a,
if it is
for
more
a-
than 2.5.
No, suppose for a hypothetical situation, this is the road level. This is my basement parking
It can't be more than 2.7
from the road level.
from the 2.7.
Yes.
It can't be more than 2.7 from the road.
No, I'm not on that hypothetical situation. I'm saying that suppose this is the road level. Now the pillar we have to increase for making the building height beyond the permissible limit. Then I am get the pillar height. Then I am making my basement parking. Then from the basement parking, if it is calculated, then the 67.3 will be diluted. That's my confusion or whether
67, 50, no, what do you call the 54, 7B, an exception to 54, 3, whereby if you are having a basement parking, a semi-basement parking or a parking, from there it will be 11.5.
But it cannot exceed 2.7.
It cannot exceed more than 2.7.
Yes. Ours is 2.9.
They may tomorrow, if they just for example, they may have the basement parking up till 2.9. It has to be calculated for the purpose of the height only as 2.7 only.
Yes.
We are not giving him the benefit of 2.7. What I am giving him the benefit or anything is, it will be only from the roof.
what I am suggesting, that the competent authority is the engineers of or the concerned staff of the municipal board, as well as the engineers of the PWD department. They have to follow these 2012-14 rules. That if I am strict to that, then maybe I do not know. But my apprehension.
No,
I'm just
why I'm
expressing my
saying it,
apprehension.
no, Mr. Dotto, why I'm saying it, this, I'm clarifying this aspect of the matter so that they can go and make the verification. If I just leave it there here, they will come up again with another thing, another aspect will come up. We need to end this litigation unnecessarily, which is going on.
We are not on the second round litigation by law. Now, my only apprehension is that if we interpret these building rules now without the aid of the views of the engineers, then there may be. Therefore, I'm seeking a leave to this honorable court that let them do it. Let them the measurement be do it as per the existing building rules and bylaws.
As per this, which I'm going to clarify.
And also taking into consideration section 54. That additionally, that if I'm confined to
Mr.
that.
Doctor, if you have any problem, there's a division bench waiting out there for a litigation.
That's your lordship. I am
absolutely.
I have every right to
no,
say
Mr. Doctor, nothing doing. Hardly it makes a difference, Mr. Doctor. This is an absolutely encourages litigation being fought between the parties. This is just spoiling the judicial time of this court. How does it make a difference? A person may have a height of 5 inch, and if this particular height, if height is just 5 inches above, how does it make a difference to you? I would have understood the Tinsukia Municipality Authority taking up that action. How does it make a difference to you?
The difference is, lordship, that the division bench has rejected their submission of concession, condonation of the.
I am not going to interfere on that aspect of the matter that he is not entitled to more than 11.5 feet.
I'm a very layman so far the construction is concerned.
Take your seat.
Lordship may have experience, but I have nothing, not a 0%. I make the building without any experience.
Heard Mr. B.D. Kaur, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner. Mr. B. Dotto, the learned counsel, senior counsel, appears on behalf of the private respondent, as well as the writ petitioner. Mr. B.D. Kaur appears on behalf of the writ petitioner assisted by so-and-so, appears on behalf of the writ petitioner in WPC number 1212/2023. And Mr. B. Dotto, the learned counsel, senior counsel, assisted by so-and-so, appears on behalf of the private respondent in WPC number 1212/2023. The said counsel in WPC number 392/2023, Mr. B. Dotto, the learned senior counsel, assisted by so-and-so, appears on behalf of the petitioner, and Mr. B.D. Kaur, the learned senior counsel, assisted by by so-and-so, appears on behalf of the private respondent. Mr. So-and-so appears on behalf of the Tinsukia Municipal Board. Board. The dispute between the petitioner and the private respondent has a long history in view of the fact that this is the second round of litigation on the same aspect of the matter. It is seen that the petitioner in WPC number 1212/2023 had the petitioner, one Gayatri Devi. It is seen from the records that one Srimati Gayatri Devi Chaudhary had taken a permission from the Tinsukia Municipality Board for construction of a multi-storied building. On 12/5/2014, a permission was granted for construction of a ground plus 4 storied commercial building. A perusal of the approved plan, which have been enclosed to Annexure 1 to the writ petition, reveals Annexure 2 to the writ petition reveals that the said Sri Gayatri Chaudhary was granted the permission for construction of a basement parking, ground floor, first floor, second floor, third floor, and the fourth floor. It is seen that a challenge was made to the permission so granted to the sage Sri Gayatri Chaudhary by filing a writ petition by the private respondents, which have been registered and numbered as WPC number 418/2018. The ordinance bench of this court, by the judgment and order dated 22/5/2018. That's the order, no?
Page
22/5/2018 had disposed of the said writ petition. By categorically coming to an opinion, finding that the RCC building has been constructed up to a height of 12.94 meters, that is 42 feet 6 inches, as against the approved total height of the building of 19.36 meters, bracket 63 feet 6 inches. Taking into account the setbacks, the coordinate bench of this court, by the judgment and order dated 22/5/2018, interfered with the building permission by making a declaration that the building can be constructed, that the said building permission shall only be held to be a valid permission only to the extent of the height of 11.5 meters of the building in question, and not to any further height. It was further observed that the illegality being incurable, the Tinsukia Municipal Board were directed to take appropriate steps to ensure strict compliance to Rule 67(3) of the Building Rules 2014. And in that respect, to take appropriate steps by way of causing demolition to that part of the building in question which offends and was in violation to the mandate of Rule 67(3) of the Building Rules 2014. It was also directed that the building in question has to be cut to size to bring it within the statutory framework dimension of the Rule 67(3) of the Building Rules 2014 by doing away with any violation thereof. A writ appeal was filed by the petitioners in WPC number 1213/2023. which was registered and numbered as writ appeal number 188/2018. The division bench of this court, by its judgment and order dated 22/4/2019, did not interfere with the judgment of the learned single judge of the coordinate bench of this court, and held that the constructions made beyond 11.5 meters in height is liable to be demolished. It is also seen that a review petition was filed by the petitioner herein, which was registered and numbered as review petition number 129/2019. The said review petition, however, was dismissed by an order dated 7/3/2022 on the ground that there was no ground which existed for exercise of the review jurisdiction. It is seen that pursuant thereto, certain steps were taken by the Tinsukia Municipal Board for taking action for removing for demolishing the excess height. And in that regard, a notice was issued on 21/1/2023, which was by the Executive Officer, Tinsukia Municipal Board, which has assailed in the instant writ petition. The record reveals that the discord, by an order dated 3/3/2023, directed no, 21/1/2023 to Luna. It is further seen that pursuant thereto, there was another communication issued on 6/2/2023 by the Executive Officer, Tinsukia Municipal Board, thereby directing the petitioner in WPC number 1213/2023 to abstain from doing any construction activities and to demolish the excess height of the building without any further delay. Being aggrieved, the petitioners in WPC number 1213/2023, alleging that they have already demolished the excess height of the building beyond 11.5 meters, have approached this court by filing the instant writ petition. It is relevant to mention that on 3/3/2023, this court had issued notice and stayed the operation of the communication dated 6/2/2023. In the meanwhile, another writ petition was filed by the private respondents of WPC number 1212/2023, which was registered and numbered as WPC number 392/2023, wherein certain directions were sought for demolition of the excess height of the building in question beyond 11.5 meters. on the ground that in spite of specific directions being issued by this court in the earlier round of litigations, there was no steps taken by the Tinsukia Municipal Board in that regard. And also on the ground that the Tinsukia Municipal Board had derelicted its duty and rather acted in collusion with the petitioners in WPC number 121213/2023. In the said proceedings, there was this court had issued notice by an order dated 25/1/2023 and there was also a further direction that there should not be any further construction in respect to the building in question till the returnable date. Mr. Kumar, why this height regulation which is given at clause 54 is in respect of what buildings? Huh?
Saying the human habitation.
I think the name I have asked Mr. Kumar. I've asked Mr. Kumar. Take your seat. Yes. Why are you referring to 54?
This is the only provision in regard to height regulation.
No, there is a specific thing for regulation for commercial 67.
67 can.
This is regulation.
67 is also regulation.
Yes, regulation.
This is for commercial buildings.
Yes. But height is not here, Your Lord.
Height is given. The 67, the regulation for commercial buildings shall be as rear.
Yes.
Minimum minimum plot size should be 167.4 square meters, while minimum width of the plot is 7.5.
Yes.
When setback is up to the height of 11.5 meters, then you require minimum setbacks of this.
Yes. Yes. But where, from which height it has to be calculated? It is not there.
And the direction which was passed by the
Single judge at page 37.
was in respect of 67 is
37. Page number 37.
by the single judge is 67,
Sorry, 1, 2,
67.3.
yes.
Additional rear and setbacks for a building when the height is above 11 years shall be as follows. If the height is above Iman, the rear setback should be so and so. How do you bring 67.3?
67.3, to have a height above 11.5, we need
Then
to
you
have
require these setbacks.
a setback of 1.5.
But how do you read the single judge's judgment? It says about 67.3. Kindly read page 35. Page 37. And is in violation to the mandate of section rule 67.3 and shall now take appropriate to ensure strict compliance to rule 67.3. Now, if the single judge has directed that it cannot go beyond 11.5, you can bring in 67.3.
Yes, ma'am. Because 11.5 means if you want to have 11.5 and all, you need to have a setback of
It will come under
1.5.
67.1.
Yes. Yes, ma'am.
It will only come under 67.
Also, 67.1.
And
2B,
67.2. It will be 67.2.
Yes.
But 67.2 or 67.3 only says about setbacks.
Yeah.
This has nothing to do with the height regulation.
That's why I was referring to 54.
Then how do you read this? Page 37. Illegality being incurable, the Tinsukia Municipal Board shall now take appropriate steps to ensure strict compliance to Rule 67.3. How, on one hand, there is a direction to make it till 11.5. And then how do you comply with 67.3? You get my point?
Yes. Your lordship is correct.
Now you tell me, how do you comply? On one hand, the single judge says it cannot be more than 11.5. If it is 11.5,
then there is a side setback, it's regulated.
no, it's okay. But if you are directing to keep it at 11.5, how do you comply with 67.3? You can't comply with 67.3 because you are, on one hand, you are directing, don't make it more than 11.5.
Correct. And
But the division bench was right. Therefore, division bench restricted itself only to say about 11.5. So the height cannot be more than 11.5. And for height, the only provision is 54.
Sorry, 57.
54.
54. And our building is residential come commercial.
Then also you go as per the density thing. So that has no relevance. This court have duly heard the learned counsels, senior counsels appearing on behalf of the both the parties, as well as the counsel appearing representing the Tinsukia Municipal Board. From the various directions which have been issued by the coordinate bench as well as the division bench of this court, it's clear that the height of the building of the petitioner in WPC number 1/2023 cannot exceed 11.5 meters. Full stop. It is also seen from the Assam notified urban areas bracket other than Guwahati bracket close building rules 2014. For short, the rules of 2014. That Rule 67 deals with regulations for commercial buildings. While Regulation 67(2) deals with buildings with a height of 11.5 meters, Regulation 67(3) deals with buildings beyond 11.5 meters. A further perusal of the said Rule 67 shows the said rule relates to maintaining of the setbacks in respect to the height up to 11.5 meters and beyond. However, from the rules of 2014, it is seen that the height regulation is stipulated in Rule 54. We are concerned with Rule 54, Roman 3, wherein it is mentioned that the maximum height of the building and additional requirements shall not exceed 3-storied or a height of 11.5 meters without following additional provisions for open space all around the building except in cases where otherwise specified. Meaning thereby that normally the maximum height of the building shall not exceed 3-storied or a height of 11.5 meters. Without following the additional provisions for open space, which can be found in Rule 67(3) of the rules of 2014. The use of the word inverted comma, except in cases where otherwise specified, inverted comma close, is relevant for the purpose of taking into consideration Rule 54, Roman 7, as to how the height calculation of the building is to be made. As in the previous segments of the instant order, this court had already dealt with that the permission which was granted to the petitioner in WPC number 1212/2023 was a permission for building a ground plus 4-story building, which also had a basement parking. In that context, it is very relevant to take note of Rule 54, Roman 7b, which, being relevant, is reproduced hereunder. Page 42. A perusal of the above clause quoted here in above shows that when a building is constructed on stilt with the provision of a ground level parking floor or a semi-basement parking floor, comma, the height of the building shall be calculated by omitting the height of the parking floor up to the maximum of 2.7 meters for the purpose of building height, subject to the provision of exclusive parking on the ground floor with special earthquake resistance measures. But for additional setback calculation, comma, height of the building shall be calculated from actual ground level. This clause, this rule, sub-rule, that is sub-rule 54 Roman 7b, in the opinion of this court, comes within the ambit of the words, inverted comma, except in cases where otherwise specified, inverted comma closed, as stated in Rule 54 Roman 3. In the instant case, as there is no semi-basement parking or any floor kept only for semi-basement parking, the question of the petitioner in WPC number 1212/2023 to get the advantage of 2.7 meters in the calculation of the height of the building does not arise. However, the petitioner herein would be entitled to the would be getting, however, the petitioner's building height has to be calculated from the roof of the basement parking and cannot exceed 11.5 meters if calculated from the roof of the basement parking. This court also takes note of that there are very serious allegations being made by the private respondents in WPC number 1212/2023 as regards dereliction of duties by the Tinsukia Municipal Board in complying with the order passed by this court. And as such, this court, for the interest of justice, directs the PWD who? Huh? Understood. P. Nayak is not going to go there and measure. Which engineer? We direct the DC.
Executive engineer building per.
And we direct the DC.
Yes.
Direct, I think we direct the DC.
DC will again relegated to municipal board.
No. DC in association with the PWD.
Oh, yes.
I think that is
Yes,
a better
yes.
thing. We direct the accordingly directs the deputy district commissioner, which Tinsukia, to carry out the measurement of the height of the building as on the basis of the above observations. And if the office of the deputy commissioner, district commissioner, Nagaon, is not capable of, Tinsukia is not capable of, does not have the infrastructure to do so, the district commissioner, Nagaon, the Tinsukia shall take the help of the concerned, the help of the executive engineer, PWD, of here division to carry out the said measurement. List the matter again on
5th of August.
5th of August 2024. The said report be submitted by the district commissioner in Tinsukia on or before the said date to the government advocate, Mr. N. Goswami, so that the same can be placed before this court. Full stop. Your name, you are appearing in these matters. State of Assam is there. Okay. Take it.
May I make a small prayer, madam?
Yes.
Instead of 5th, madam, lift me on 12, madam, I have my daughter's exam. I have to accompany her.
What?
Daughter is appearing for her PG entrance. Or 12th is Monday, madam.
Okay, well.
Madam, there is one more clarification. In the order of 25/1/2023, this honorable court has stated that construction activities even below 11.5.
Let it remain.
But
The
there was no
interim
extent-
orders which have been passed shall continue till the next day. I've seen it.
Your blessing.
What is this? Excise. Tell me. What is your case?
The licensee of the wholesale warehouse. Year 2016, with the direction from the excise department to. And on the basis of that, the excise department has find a stock saleable and non-saleable. And on the basis of that, we have been directed, the order has been issued for paying the levy and VAT on the saleable. Accordingly, we have cleared the amount the year 2018. And thereafter, they have again re-examined of the saleable and non-saleable. And then another fresh demand has been.
Yes, Mr. Botako, there was one matter which I kept it as part of, then the matter has gone for a 6. What happened?
Lordship, that is a part-heard matter in Code 20. But
Yeah.
Code 20, Lordship.
That is the same issue here. Because
it-
what happened is as to whether you are entitled to levy on goods which are otherwise
it was-
not fit for human consumption.
Lordship, that issue is similar, Lordship, with that one, but otherwise, Lordship, the finding regarding which, how much was saleable and how much was non-saleable, that is also being challenged, Lordship. And in the last occasion, Lordship, we had raised the issue of, Lordship, delay because the demands originated in 2017 and 18, the impugn demands,
And they are making it now.
Lordship, in 2023.
He has deposited 25 lakhs.
I have been informed that it has not been deposited.
I have been deposited because in the year 2022.
Have you deposited the 25 lakhs?
Because I have.
In view of that, this court is of the view that no coercive action be taken against the petitioner in putting any hurdles in running as subject to payment of 25 lakhs to the department. Huh?
That has been deposited
When?
immediately, my lord. After the court order, my lord, immediately that has been deposited.
He has instruction not been done.
Can produce the, my lord.
How can he produce
Then
something which is not in existence?
I will produce that. my
It
lord.
is for you to
My lord, my
produce. You have deposited, it is your burden duty.
My lord.
Mr. I. Bottakur, appearing on behalf of the respondent excise department, submits that to his information, the amount of rupees 25 lakhs as directed by the order dated 10/3/2023 have not yet been deposited. On the other hand, the counsel appearing on behalf of the petitioner, Mr. S. Sharma, submits that the amount have been duly deposited. List the matter again on 2nd of August 2024, on which state the learned counsel appearing on behalf of the petitioner shall produce as to whether produce the documents showing that the amount of rupees 25 lakhs have been deposited immediately as stated, as submitted before this court.
I don't. Okay.
15.
Yes, what is this?
Lordship. We have filed on affidavit, Lordship. Case was registered, Lordship.
None appears on behalf of the petitioner on call. For the ends of justice, the matter stands adjourned to be listed again on 2nd of August 2024. It is made clear if the petitioner is not represented on the next date, the instant petition shall be, it will be presumed that the petitioner has lost interest in the instant proceeding.
That Lordship will take up this matter on Friday, my lord. I have to take.
Right.
I have to receive some instructions from my client.
Huh?
I have to some instruction, my lord.
What instruction? Is the case of a petitioner that who are in 5 in numbers that they are What deprived? What case you have? You are on an apprehension. Nothing has happened since 2023. Nothing remains.
But even the deputy commissioner in the affidavit has says that, my lord, pursuant to the letters, no settlement process is going on. my lord.
So what? Settlement position, it will continue. If you don't get it, you come back.
My lord, my Lordship.
What? What are your names?
Premika Angel, Ajit.
It Angel, Rajiv Angel, Shivwad Angel, and Angel. All these Angel. Herman Angel. Are the recorded tenants on so as well. The conversion of land. Oh, not in the process of allotment. Then what remains?
My lord. The land was allotted in the name of the father in the year 1976.
You don't get it, come back. Nothing doing. Shall not be directed to forthwith pass necessary for fixation of revenue for conversion of the land to Miyadi as per the provisions of so and so. Process for fresh allotment of. Why should we do it? That is dependent upon the court. Yes, you are, if you are entitled to your recorded partners or the rights or the, you will obviously get in terms with 16. Why should this matter be pending?
My lord, what happened, my lord, pursuant to 16, my lord, the father, after the death of father, during the lifetime of father,
due to financial constraints, he is not able to pay the the premium Then after the death of the father, this petitioners have approached the authority, and the authority has processed the applications. But they are processing as if it is a trust settlement.
Huh?
They are processing my allotment as if it is a trust settlement.
You say that you come under the ambit of 16. Because your father's name was duly recorded, isn't it?
Father died in 2004 lot.
Huh?
Father died in 2004 lot.
Then
Now they came lot. 2018 lot.
father was a righty. Your father name was there.
Yes, sir. Yes, yes. That is the clear lot.
What is the father's name?
German Angel.
Father's name is what?
German Angel.
Huh?
German Angel.
German angel. Okay. And in the affidavit, they have said,
Yes,
duly
sir.
mentioned that he was a righty.
Yes, para 5 lots. Case 43.
The instant petition heard Mr. A.K. Gupta, the learned counsel appearing on behalf of the petitioner, Mr. N. Goswami appearing on behalf of the respondents.
3, 4, 5, and 6.
Respondent number 5 and 6, Mr. A. Bhachaji appears on behalf of respondent number 1. Instant writ petition has been filed by the petitioner being apprehensive of the fact that the respondent authority shall not consider the cases of the petitioner in terms with section 16 of the Assam Fixation of Law of Sealing on Land Holding Act 1956, wherein they have a right to settlement upon the land being declared as sealing surplus. Court have duly taken note of the affidavit which has been filed by the respondent number 3, wherein it has been duly mentioned in paragraph number 5 that as per the report of the circle officer and the assistant settlement officer, Chandrapur Revenue Circle, the petitioner's father was a recorded tenant, Royat of Dag number 71 and KP Pata number 10 of H. Hazongbari, Moza Panbari, as per sealing case number 741/76 and 700/76. Taking into account the same statement which have been made on affidavit, this court directs the respondent authorities to duly, while considering the case of the petitioner, duly consider the provisions of section 16 of the Assam Fixation of Land Sealing Act 1956, as well as clause 2 of the land policy of 2019. The above the petition stands this court.
Time frame to consider this.
Absolutely no. While considering the case of the petitioner, this will be done. Your apprehension is they are not going to. This is your apprehension being cleared.
Wait, please, your lordship. Lordship, it become infructuous.
Huh?
Infructuous.
Infructuous. The learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous. So taking into account the above, the instant writ petition therefore stands closed as on the ground that it has become infructuous. Interim order dated 17/3/2023 stands vacated.
So your affidavit was not filed by the.
What is this? Huh? Your land has been taken or not?
Land has been taken now, my lord, but earlier when we came in 23, they have earmarked our land where Assam Mala Road will First, since this is a six schedule area, my lord, all land are non-cadastral. Non-cadastral. So therefore, NOCs are issued by the competent authorities. If they are in the possession, my lord. Now, my lord, in the meantime, part of our lands are already been, my lord, started construction.
They've taken.
Yes.
Have you been paid a compensation?
No, nothing, my lord. There is no, my lord, procedure adopted. They have no.
We have sent a proposal which was given to PWD the last.
But Mr. Borua, have you amended your petition or filed an additional affidavit bringing on record that at that point in time you were under an apprehension? Now they have already taken?
Page 35, so my lord. Kindly see, my lord, page 35. The re-verification, they intended to commence from February, my lord.
Understood, but I am asking you whether you have mentioned the said aspect of the matter
To the authority.
by way of filing a affidavit. Tomorrow, if I have to take into account, how do I take it? Mr. B. Bulwer, the learned counsel appearing on behalf of the petitioner, submits that at the time of filing of the petition, the lands of the petitioner were only earmarked for being used for the Assam Mala project, Mala road project. However, during the pendency of the instant petition, the lands have already been taken. To stop. The learned counsel submits that he would like to file an additional affidavit to bring on record the same respect to the matter. The matter after 2 weeks.
One.
Please, your lordship.
Yes,
The
ma'am.
subject matter of this petition is pending adjudication before the Supreme Court. That possibly listed next month at the status. So there is an interim stay in this matter. And but the board has also given a clarification on 1/4/24. Another one for all zonal railways, 36. That the attention should be guided by the 2010 policy.
What has happened matter before the apex court?
Listed possibly next month.
Sorry? No, in the month of May it was happening. What has happened?
I'm made to learn that there was some defect, so they have refiled the SLP. They have refiled the SLP.
That 2016 judgment has no relevance. That was prior to the policy. Earlier policy had a different clause now. Now you have to go, there's no extension can be granted. It has to go for a year.
My lord, 20.2.
Of
Catering policy of 2017.
2007.
17. That
20.2 page.
Page 102.
100 and
Tenders that have been finalized and LOA issued prior to the date of notification of this policy.
20.2 tenders that have been finalized and LOI issued prior to the
Shall be allowed to continue as per policy guidelines.
prevailing at that time.
All tenders. You were issued an LOA as per the earlier policy.
Yes.
That will be again, my lord, till the expiry of the period of.
That period. That period has ended.
Already over.
Because my lord, LOAs were issued prior to the.
You cannot get it for all life to
Yes.
come. Nothing doing. No case.
Zonal railways have been extending. And
Case,
also
no case.
the other high courts. So my lord, let us await the outcome of the SLP.
Huh?
My respectful submission is that the outcome of the SLP will have a hearing on this case.
What has happened? You have not, there is no stay. Then, what is there? We are bound by the judgment of the division bench. Division bench dismissed it. That is why I read appeal. 11/3/2024. Then, what do you mean? What has happened in Delhi?
Bombay High Court Division Bench has, however, extending the stay.
Bombay High Court good. Do it.
Has been made absolute.
No. What will happen to all the other people? Provide the tenders have been finalized and the letter. I'll have to contest. So all this problem arose because of my judgment. Yeah?
And
My lord has clarified it that there will be no renewal.
Huh?
There will be no renewal under the 2000.
No renewal business, nothing doing.
New policy.
Because that judgment of 2016 is on a different aspect. At that point of time, that policy was being taken into account. 2017, therefore, they came up. Anyways, what to do? When are you going to get the high cost there? You don't get the order, there's no way out. And has this Deepak and Co. have they been thrown out? Huh?
Because of the stay, my lord, they have not been.
No, here Deepak is not here.
Yes, he has been, yes.
They have been thrown out.
Yes.
Oh, then how do you get a benefit? The person who has filed an appeal, SLP has been filed by that person who has already been thrown out. And you want to take the benefit.
the stalls have been locked, that's all. Because
Lock her stall.
that's my instruction, the stall is.
Your stall has been locked or not?
My stall is functioning.
No, you can't.
Deepak and Company's stall is locked.
That person who is going to file an SLP, he is filing an SLP, his stall is locked, and the person who wants to take the benefit of that SLP, his stall is ongoing. That can't happen, man. That is not heard of.
Because my lord, in my case.
Now tell me, give me a good justification on that.
My lord,
That the stall of the person whose order is going to benefit you, if he is capable of getting an order in the Supreme Court, his stall is closed and your stall is running.
other courts, my case is for stalls running in other zones.
You should have filed a petition there in those courts.
That I'm getting interim status quo.
So go there. Which courts?
Ernakulam High Court and then
Go there, Arnakulam.
Bombay High Court and.
Bombay. Go there. You would want the liberty.
My lord, let us await the outcome of the division bench SLP.
How? You are not there in SLP. The person who is going to SLP, his stall is already closed.
Yes, my lord.
Then how do you get a benefit? Tell me.
And in my case, interim status quo is there.
That is what I'm vacating.
My lord.
I'm vacating this because there is already an order, judgment passed by me earlier. That was followed by that went to the division bench. The division bench did not interfere with that judgment. And thereupon another judgment has been passed by Justice Brother Michael. And thereupon the matter went to the division bench. Division bench did not interfere. Then two courts. Why did you file it here in Guwahati? You should have filed it in Ernakulam. Take it up at 2. Getting it.
Will give me some time. Let my senior come and.
2 o'clock.
Not today.
Second half.
Yes.
Lord has paid, affidavit in the record. That I take your lordship to page 155.
Yes.
Tenure of the license.
Hmm.
Tenure of this license shall be initially for a period of 5 years from the date of commencement of the license, with a provision for further renewal for period of 3 years on satisfactory performance and payment of all dues and arrears and withdrawal of court cases. And then the last line, the terms and conditions for renewal will be governed by the 2010 catering policy. And other instruction, the license agreement shall be as per section D of the bid document. And at page 161 is the disclaimer clause.
Page
161 is the disclaimer clause. The disclaimer as set forth at the outset of this document and the license agreement as stated in this document shall be deemed as a part of this document. And then, my lord, at page 199. Tenure and renewal of license. The tenure and renewal of license shall be initially for a period of 5 years with the provision for further renewal for period of 3 years on satisfactory performance and payment of all dues and arrears and withdrawal of court cases. Then,
So how long you have been running?
my lord, I was issued the LOA on 3/2/2017 prior to the commencement of the 2017 policy.
So it's 5 years
5 years.
till
then
22.
Thereafter, till further extension of 3 years, I meant.
Have you been granted an extension?
Yes, my lord.
Where?
Because of this COVID, I got a year extension.
Now
and
where is that extension?
That is possibly not on record.
Then there's no extension. Because this was made in the year 2014. And after that 2017, the law has changed. They have come up with a different thing. You have filed affidavit, union?
No, no.
Huh?
It has not been filed because the depending on the writ appeal is pending, my lord.
Huh?
Writ appeal 124, my lord, that covers the.
Yeah, issue is covered.
Otherwise, my lord, if your lordship grants me a week's time, because the SLP I'm informed is listed next week.
When?
Next week on tentatively on 2nd or just.
I checked it yesterday, well, it has not been filed, I think.
No, it has been filed. I was informed.
When? SLP number,
SLP has been filed. I have given.
SLP
your
number,
Right.
but diary number.
Yesterday's copy I have given lordship. The diary number is 24269 of 24.
The learned counsel appearing on behalf of the petitioner submits that the SLP has already been filed and which bears diary number
69
24269
oblique 2024.
24 and is likely to be listed next week before the Supreme Court. To stop taking into account the above, list the matter again on 2nd of August. Yes, Mr. R.K. Dev Chaudhary. This motion, copy was given to you, none has appeared.
In fact, they had served a copy in my office. They have got a standing counsel, I forwarded it to their office. But in any case, in a similar matter, I had appeared. It's on their
No,
instruction.
here the issue is very small.
Worship had decided, not decided exactly. Worship has passed some orders in another.
No, that is in respect of another one.
Another case.
Where there, I have passed the direction that there should not be allowed to be used.
Yes.
That amount should not be allowed to be used from Axis Bank. That is one aspect. But the thing is, why he is asking, his entire basis of the repetition is that you are having three authorities. One is the Jaipur officer in charge of Jaipur police station or something. The second is the Guwahati division. And the third is the Nagaland division. Now, this adjudicating authority has passed an order in terms with the Nagaland division. He says, the Axis Bank says, okay, we are going to transfer it to you, provided you get the no objection from the other two authorities. That is the limited thing. So, why you are not taking that same? Otherwise,
In fact, it is the Nagaland division which will be the authority.
the Guwahati division otherwise has no business
No.
out there.
It will be the Nagaland division. This
So,
arises-
I think we'll have it, let us have it next week. You
Sure.
take the information. I think because of the Jaipur thing, they have asked for freezing. Jaipur asked the freezing and also the Guwahati division.
The respondent number 1, it is the Enforcement Directorate, New Delhi. The respondent number 2, Enforcement Directorate, Guwahati Division. And the respondent number 4, it is the police station of Jaipur Police Station.
Who is number 3?
Yes, madam, I'm coming to that. The account is under debit freeze under the direction of respondent number 1, 2, and 4. Now, my lord, the respondent number 3, who is the Enforcement Directorate, Dimapur Subdivision, all of a sudden, he directed us to hand over the money.
No, there is a reason why, because that is done under the statute. Because in that case only, the adjudicating authority has already decided in terms with clause section 8(4).
Yes.
So under such circumstance, you are under a statutory compulsion to do so. But the only problem arises in view of other two enforcement directed divisions taking up also doing this.
Yes,
so they have to only come up with that aspect of the matter as regards getting the what you call the no objection from that. So if the enforcement directed 1 and 2 gives the no objection, matter is over because 4 has no relevance of the.
My lord,
Here, Lordship is aware, Lordship, it's the same case which Lordship has dealt with in Nagaland. But Rupesh Arora. So they have got many accounts, and in fact, the investigation was done by the Dimapur division. So perhaps, Lordship, that would be the authority.
No, therefore you get the no objection from the other two. Because 1 and 2, if they give the no objection, that then the 3 thing has to be complied with because that is the statutory mandate. We are not concerned with what the 4 does. 4 has no business.
Respondent number 4 is also directing us.
Understood. 4 has no business because the 4's direction is overshadowed by the statutory compulsion in view of section 8.4. 8.4 will take it. But only thing is 1 and 2 being the same investigating agency, to let them get a RIA. We'll have it next week.
Yes,
You get that only the no objection from the other 2 have no objection, matter will be over.
Gosh, yes.
Can it be after 10th of August, but from 3rd to 8th, I will be out.
Ask somebody else to appear in the matter. Oh, okay, no stay. No stay. You get it next week.
That my lord. I will arrange my lord.
Issue notice. Making it returnable on ninth of August 2024. The petitioner is directed to take steps upon Mr. Arkadeep Chaudhary appears on behalf of the respondent numbers 1, 2, and 3. As regards the respondent number 4, the petitioner is directed to take steps by way of registered as well as usual. In addition to that, the petitioner is also directed to take steps by way of the state, routed through the registry of this court and file an affidavit of service on or before the next state. The issue involved in the instant writ petition is on a very limited scope. It is seen from the materials on record that the respondent number 1, 2, and 4 have issued certain directions to the petitioner bank to keep the accounts in question, a bank account in question of one whose name? Bank account of whose?
Analytic Business Ventures Private Limited.
Account of one. No, Santosh Chaudhary. What?
Except December 31, my lord.
No, this officer in charge of Jaipur's only gives to Santosh Chaudhary.
So there are several banks account and
No. This annexure 1 is only in respect of Santosh Chaudhary. We are not concerned with others. Is this the same bank account?
yes, my lord. Annexure 1, 2, and 3.
We are concerned with which account?
The last one, 9220-200. So and so.
But that is but the bank account of Analytic Business Venture is only account number 4099108933733. That's the bank account.
No. The last person of annex to 1, my lord, this person.
That is for of Santosh Chaudhary. Kindly see page 30.
Analytic Business Ventures Private Limited. Name of the account, page number 30. Double three.
We are only concerned with 92202334999564.
564.
Annexure 3 does not include that bank account.
But annexure 1 and 3 is a similar matter, but annexure 2, perhaps it is wrongly typed here.
Annexure 3 is of that bank account.
Yes,
this is
Analytic.
to Amit Agarwal, so and so of Analytic Business Ventures.
Yes.
But whose account it is? Annexure 1 may say this.
Annexure
But Annexure 1 may say this, but it does not belong to Analytic. This is they mention is the inquiry reveals that accused, namely so and so, involved in fraud of crores of rupees, and as such, the bank accounts are required to be kept on the deposit freeze. We are concerned with now Annex 3 because this action is being taken against NLIT. Huh? Okay. The issue involved in the instant petition is limited. In as much as the respondent number 1 and 2 had directed the branch office of the petitioner bank to keep the bank account number 92202034999564 of MS Analytic Business Ventures Private Limited as in a debit freeze mode, and should not, and also with a direction that no permission should be granted for use of the same without the prior permission of the Deputy Director, Dimapur Sub-Zonal Office Enforcement Directorate, Guwahati. The record further reveals that the respondent number 3, pursuant to an order of provisional attachment, which have been confirmed by the adjudicating authority in terms with Section 8 of the Prevention of Money Laundering Act 2002, had confirmed the said provisional attachment order and issued a direction to the respondent petitioner bank to make a demand draft of the frozen amount and pay to the Joint Director, Enforcement Directorate, payable at Guwahati. The petitioner herein has approached this court on the ground that pursuant to the said communication so received on 12/4/2024, the petitioner have contacted the respondent number 1 and 2 along with the respondent number 4 in respect to the direction of for compliance to take so that appropriate action can be taken in terms with the communication dated 12/4/2024. However, the said respondents have not replied to the petitioner. It is under such circumstances the petitioner has approached this court for appropriate writ, direction, and order. It is taken note of that there is another writ petition pending before this court in respect to the said freezing of the bank account of the petitioner of the said analytic edu.
It's a different.
Oh, it's a different one. Okay. It would nalagi. It's also seen there another petition. This has nothing to do with the earlier petition, which is pending.
In fact, the entities are different, but the transaction, the fraud that has been committed, it happens to be the different entities. This is one of them.
Because last time when the matter came up before me, you said that this has the same connection with the Nagaland matter.
This also has the same connection.
But different entities, different bank account.
Taking into account that a confusion has arisen in view of a direction issued by the respondent number 1 and 2 for thereby directing not to allow any debit of the account in question. This court had asked Mr. R.K. Dev Chaudhary, the learned counsel appearing on behalf of the respondent number 1 to 3 to obtain necessary instructions. On the said date, on the returnable date, the Mr. R.K. Dev Chaudhary shall place before this court as to whether the respondent numbers 1 and 2 has no objection towards the compliance of the directions issued to the petitioner bank by the respondent number 3. Place on record as to whether the respondent number 1 and 2 has any objection to the compliance of the directions of the respondent number 2 to the petitioner bank.
Till then, my lord, the operation.
Huh? What operation? Operation is already under freeze.
Yes, sir. My lord, the direction issued by the no coercive action against the petitioner bank, my lord, till then.
I will apprise the court, lordship.
Otherwise, they are pressurizing the bank official every day, my lord.
I'll pass on the instructions.
I therefore said that next week.
Yes,
It could have been done on Monday. Why are you not having it on Monday, Wednesday? Let's have it on Wednesday. Nothing is.
On Wednesday, it can be done, my lord.
This Wednesday, lordship.
On 31st? On 31st?
On that.
On 31st, it can
On
be done.
31st, issue notice on 31st. Huh? Yeah. Till the next date, no coercive steps be taken by the
Lordship.
respond number 1, 2, and 3 upon the petition.
Obligement.
30%. Item 3.
Yes, why you are not complying with it?
The process is on, my lord. In the meantime, 33% given the notice, hearing is going on. And there are some other complaint has also come. One of the complaints all went to the chief minister also that we are not doing it properly, my lord. Well, let me get the full instruction and final affidavit. But
Yes,
you will show my name, my lord, in the cause. You will show my name in the cause list.
It's okay. I'll notice making it. How long will it take?
3 weeks, sir. 3 weeks, sir.
This turnable on 19th of August 2024. Steps upon the sole respondent be taken by registered as well as usual. Contempt proceedings is stated against on account of the willful and deliberate violation to the judgment and order dated 3/10/2023 passed in WPC number 3185/2019 and others. It is seen from the said order, said judgment and order that there was a direction to hand over the possession of the flats to the petitioners of WPC number 3185/2019 at the earliest and not later than 60 days. The record further shows that on 19/10/2023, the respondent have been duly apprised about the said directions. However, till date, nothing has been done, even after a passage of 8 months. The respondent contemners shall, on the returnable day, apprise this court as to why the order passed by this court had not yet been complied with. This court also had requested Mr. as Bora, the learned standing counsel of the GMC to assist the court take compliance of the order passed. The Hezbollah shall also obtain the registry shall show the name of Mr. Hezbollah in the cause list. Yes, what is this?
This matter regarding ex gratia, Your Lordship.
Huh?
Matter regarding ex gratia, Your Lordship. Here the
Has expired in the road exit. Ulex.
Yes.
Now, recently, Justice Surana has passed some order.
Yes.
What is that? If a person is already entitled to getting any benefit under the some policy, he would not be entitled to.
You're not.
Yeah.
Yeah, my lord, that of course, that.
Are you getting the benefit?
Because Your Lordship, perhaps that order might be on the basis of Sasi Sharma.
Huh?
Sasi Sharma. Yes, yes.
No, recently a judgment has been passed by the coordinate bench in this regard. That in the circumstance, a person he is already getting benefit under some policy, he would not be entitled to this. This is only applicable if it's a case of hit and run accident.
Yes, and if, in fact, my lord, this notification dated 15th of November 2014 have been, my lord, modified. By this notification, I have already mailed it, my lord. Otherwise, that only in hit and run cases, my lord, they will be entitled.
Hey.
My lord, in the first paragraph. In the first paragraph, lordship will find it.
This has come later on.
Yes, Lordship.
Just
November of
later on.
2022.
This has come later on.
But the judgment interprets 1511.
Yes. That is true, but here, my lord, that aspect of the matter that only hit and run cases will be covered by this 1511.
Understood, but that is in 2023.
2023 maybe, but now the list is before us, my lord. So therefore, my lord, lordship may take note of, my lord, this notification.
How? Because this you have modified only in 2023.
Yes, we have modified it 2023 in supersession of the said OM notification.
Understood. So as on that date, when the accident happened, this was it. He made a claim at that point of time. Only in 2023 you changed it. So under such circumstances,
this may not have a retrospective effect.
This may not have a retrospective effect. But what do you say about Justice Surana's order?
Yes, definitely. That
you have
I'm
a
sorry,
copy
my
of
lord, I
Justice
couldn't-
Surana's order?
Yes, my lord, just I couldn't get the copy, my lord. I should have it, my lord.
Justice Surana's order says,
My lord.
this is it. In the case in hand, the claim of the petitioner is that her husband was killed due to an accident in public place which comes within the ambit of serial number 3. It is not in dispute that the petitioner can pursue her remedy for claiming motor vehicle accident before a year. In so and so, the Supreme Court held that a claim based on a contract cannot be the question is whether a petitioner is entitled to ex gratia when just and fair compensation for accident involving motor vehicle can be otherwise claimed before the motor accident tribunal. Envisaging grant of compensation is found to be relatable to provide ex gratia and finally to person who are killed in so and so, so and so, so and so. Therefore, the accident must be in relation to the acts committed by extremists, miscreants, so and so and that. The same notion cannot be read as if all persons suffering from an accident except hit and run when offending vehicle remains unidentified in the final form after the police investigation would be entitled to an ex gratia, where other statutory remedy is available. The court is aware of its limitation when it relates to precedential value of so and so demand. Moreover, it is brought to the notice that he has taken note of the others exception. Therefore, the court of the year cannot be applied to the present case. Points and dismissed. So, in view of this, what he is, have you got anything from that amount?
No, no, as per last inspection of for my client, after receiving the notice which was issued by the honorable court.
No,
the
no,
concerned
no, no,
authority
I'm
has been
asking you. Did you get any money from that person? Hit and run.
No, no, sir.
Huh?
Not that.
No, did you file any application?
I have to take inspection.
You get your application. File an affidavit as to whether you have approached, whether the final report has been given as regards a particular car. If the car is identifiable, then obviously you can initiate proceedings under the insurance MACT. If you have not done it, then it is your lookout. I hope. The instant case pertains to non-payment of the dues, not on payment of the ex gratia grant to the petitioner on account of the death of one Kondopo Deka, who expired in a road traffic accident. Mr. Arbo Pujari, the learned counsel, has drawn the attention of this court to the judgment of the coordinate bench dated 21/6/2024 in WPC number 2700/2023, wherein the coordinate bench of this court categorically held that the notification dated 15/11/2014 cannot be read as if all persons suffering from any accident except hit and run case where offending vehicle remains unidentified in the final form after police investigation, would be entitled to ex gratia where other statutory remedies is available. Taking into account the above, the counsel appearing on behalf of the petitioner is directed to apprise this court by filing an affidavit. The petitioner is directed to file an affidavit, apprise this court by filing an affidavit as to whether any final form charge sheet have been submitted by the police in respect to the motor accidents claims in respect to the accident in question, and as to whether the vehicle in question, the offending vehicle in question, have been identified. List the matter after
filing the additional affidavit.
What?
After filing the additional affidavit. After filing the additional affidavit.
When? When are you going to file?
After 3 weeks.
List the matter again on 19th of August 2024. 23.
I'm applying.
And this is something good has happened. Otherwise, it was unnecessarily government was paying.
Yes, my lord.
Yes, next. Yes, Mr. AHMR Chaudhary. What is this?
Issuance of Aadhaar card. Non-issuance of Aadhaar card.
Why?
One affidavit has been filed, my lord, but I not under-
Why you have not been issued the Aadhaar card?
Please, your lordship. Lordship, I'm appearing on behalf of the learned CGC B. Deka. He could not appear as his wife is admitted in the hospital, Your Honor.
Huh?
Your Lordship, a similar matter is pending before the Honorable Supreme Court, Your Honor. And in regard to that, we have already filed affidavit, additional affidavit for the respondent number 1, 3, and 4, Your Lordship.
You have been declared as a foreigner. Then, why you have not been issued the Aadhaar card?
But no, my lord, 4 times, my lord, he appeared, my lord.
And why the matter has been pending since long?
Now, my lord, now I have been.
And what is the
Yes, my lord.
yes, submission with demand. I have the honor to submit the pairwise comments. Got something. Appears from the enrollment number that the applicant has given biometric denewing NRC. For this reason, the political has said that those applicants have some claims and are you going to say that till the matter is pending before the Supreme Court in respect to the NRC, those people who have submitted their biometrics, they would never be considered, though they are Indian citizens?
I have no objection, Your Honor, if the, I have no objection, Your Lordship, if the Aadhaar card has been issued to the petitioner.
Fantastic. You
But
record
it's
that?
pending in the Supreme Court, Your Honor. The similar matter is pending in the Supreme Court, but I have no
What
issue
is matter pending before the Supreme Court?
regarding the Aadhaar card, Your Lordship.
What is it? What is pending? Tell me. Now in the NRC, your name is there. Oh, that is the reason why. And that matter is pending before the Supreme Court. But are you getting all the other benefits?
Because of Aadhaar card, my lord, even your lord, it is aware, my lord. Yeah. Bank account also, my lord. Aadhaar
Then?
card is required.
What has happened recently? This is an old matter. Supreme Court, what has happened recently in the Supreme Court? Anyways, we do one thing, we adjourn the matter next week. Is there your person?
Lordship.
Taking into account that the standing counsel, the counsel appearing on behalf of
B. Deka, CGC Council.
the counsel appearing on behalf of the CGC, Mr. B. Deka, is unavailable. The matter stands adjourned to be listed again on 5th of August 2024.
Public.
4.
High Court's classification line has been going on over the land of the petitioner. Accordingly, petitioner his house has the respondent number 1, that is the Parvin corporation, has already occupied the state court of without making any personal proper assessment. No compensation has been. Lordship, that is the joint Patada. Other two Patada has already.
Who is paying for the respondents?
I filed a petition.
You are acquiring his land. You've
Lordship,
taken his land.
Lordship, no land was acquired. Lordship, only surface damage Lordship, for surface damage, we have paid the compensation.
They paid that to the petitioner.
Lordship, Lordship Circle Officer has Lordship given a report, Lordship, that is annexure, Lordship. 101, Lordship.
Yes, what does he say?
Lordship, with reference to the subject cited, I am to submit here with allotment report of Jirat inland, Deveshwar Roy, Soneshwar Roy, Satyan Roy, village so and so, in connection with concern so and so. And accordingly, we have paid the compensation, Lordship.
So,
Lordship petitioner is the.
we are concerned only with the petitioner. Have you paid the compensation to
Lordship
the
petitioner
petitioner?
is not entitled because Lordship, his land was not acquired. Lordship, the crops, Jirat, which was damaged, Lordship, for during the erection of line, Lordship, we have paid compensation to that owner, Lordship.
Petitioner had not been affected.
Not Lordship. Not Lordship. Only surface damage, for surface damage, Lordship, we have paid the compensation.
This is under the power grid system.
Power grid, Lordship.
So if it is done by the power grid, then there is a act out there now. What is that act?
Indian Telegraph Act, my lord.
This will come under telegraph.
Yes, Lordship.
So he can go under section 10.
Lordship, Thora district.
Go to the section 10 before the district judge.
Lordship, prior go to the district judge, Lordship, the executive magistrate and the district commissioner is the appropriate authority, Lordship. They have to make assessment, Lordship.
Understood.
First,
They
have to
say
make
that
authority.
their categorical stand is that you are nowhere affected.
Yes,
Look,
If
Lord,
that
you
is
know-
the ground out there, then in that regard, the question is that you have to go under section 10.
Lordship.
10 na?
And Lordship, he has not filed any reply of my affidavit also.
Lordship, kindly come to the annexure 2, page number 26, Lordship. Wherein, Lordship, our house has been demolished, Lordship. That is the categorically mentioned, Lordship.
Where?
Annexure 2, page number 26 in our lead petition, Lordship.
Where is the proposed locations of the tower? And the stringing of the power cable comprises of parts of the land owned by Binita Borua, Bina Ray, Manoj Kumar Ray, Moniram Ray. Moniram Ray, you.
I am one of the petitioner, Lordship.
Dark number 28 and 21 is under Sidley. Then, and why, who is the other? Thiren Kumar Roy is who? His name is not there.
So, Lordship, in this order passed by the executive magistrate, Lordship, and Maniram Roy is the petitioner, Lordship, in this case. And Lordship, accordingly, last line, Lordship, whoever directed task, Lordship, Maniram Roy, bearing dark number so and so, already communicated through the notice served and in the vicinity of the aforesaid land. Lordship, accordingly, Lordship, after receiving such notice, Lordship, our house has been already demolished, Lordship.
So,
We
Lordship.
were shifted from one place to another one, Lordship.
Lordship, that is
Only
not in
because
the
of the
pleaded case, Lordship.
transmission line going over the said plot of land, Lordship.
Lordship, that order is, Lordship, that who is the landowner, Lordship, only, Lordship. There is no specific statement that his house is demolished, Lordship. This is false statement, Lordship.
So, Lordship, our statement has not recorded by the district commissioner.
No, Lordship.
The deputy
Kindly
commissioner.
peruse that order, Lordship.
That is a
as a whole,
mandatory
Lordship.
provision,
That
Lordship,
is
as
not
per the-
for the Lordship. That under
for the electricity
additional district magistrate inquired that name of the partner is one petitioner is one of the partner, Lordship. But Lordship, his land was not acquired, Lordship. Only for surface damage, we have paid the compensation to the owners of land, Lordship. And
No,
his land-
here, no, kindly see this particular document, Mr. Please see this document at page 30.
Yes, Lordship.
Further, the
Yes,
last
Lordship.
paragraph. Further, this is also to inform you that one of the joint pattadas, Sri Moniram Rai, son of
Yes.
so and so, estimated verbally that a part of the compensation prepared against these three beneficiaries shall be given to him. Therefore, it is also requested to take care of this matter while disbursing the checks.
Lordship.
Then what happened?
Because, Lordship, he verbally objected that he is also entitled for compensation, Lordship. That is why we have requested the circle officer to verify the issue, Lordship. And thereafter,
And where did the circle officer verify?
Lordship.
Page? This verification 101. And what is this
Yes.
case?
Yes,
Money
Lordship.
suit?
101, Lordship.
Money suit or what?
Money shoot, Lordship, the person who got the compensation for surface damage, Lordship, they have approached the district judge, Lordship, for payment of adequate compensation, Lordship.
Under section 10,
Lordship.
they've got it.
Yes, Lordship. And accordingly, we have disbursed the amount, at the, Lordship, amount plus 8%.
2021 itself.
Yes, Lordship.
And this petitioner was not a
Not
party.
approached, Lordship, never approached, Lordship.
Go, section 10.
Yes, Lordship, definitely I will go to the district judge. Prior go to the district judge, Lordship, the executive magistrate. Or either the district commissioner also have been examined and passed an appropriate order, Lordship. Whether I am entitled to get or not, Lord. If I am not entitled to get and agree upon the order passed by the district commissioner, Lordship, definitely I will approach before the district judge, Lordship. I am entertaining provision of the telegraph, Lordship, under section 16, Lordship.
Lordship, here in this case, Lordship, they have approached the district judge, Lordship, because their, Lordship, surface damage was, Lordship, for surface damage, they got the compensation, and accordingly, Lordship, they have challenged the compensation amount accordingly. But in this case, Lordship, is not land acquired, Lordship.
Yes.
Mr. M. Saikia, the learned counsel appearing on behalf of the petitioner, Mr. R.K. Deka.
R.K. Talukdar.
R.K. Talukdar appears on behalf of the power grid.
Lordship, 1, 2, 3, and 4.
1, 2, 3, and 4. Mr. Arbo Pujari appears on behalf of the respondent number 5, and Mr.
6 and 7.
S. Bolwa appears for the respondent number 6 and 7. The petitioners herein are aggrieved on account of the non-payment of compensation by the respondent authority, respondent numbers 1, 2, and 3, 1 to 4.
1, 2, 3, and 4.
1 to 4 in terms with the on account for on account of erection of the transmission line towers stringing of transmission power cables for transmission of 800 kV HVDC higher voltage electricity from Biswanath Sariali to Agra, commencing from March 2010 to March 2015. It is the case of the petitioner that the petitioner's name was duly mentioned in the order passed by the Additional District Magistrate Srirang dated 5th of March 2015. However, the petitioner was not paid any compensation. Under such circumstances, the petitioner has therefore approached this court. It is seen that a dispute had arisen as regards the payment of compensation to the petitioner, and as such, the chief manager of the respondent numbers of the respondent number 1 had requested the circle officer Sidli Srirang district to take note of to make necessary verifications as to whether the petitioner herein would be entitled to the payment of compensation, or as to whether Sri Debeshwar Roy, Sri Satyam Roy, Sri Someshwar Roy, on the other hand, would be entitled to compensation. It is further seen in that the circle officer had given a report that the petitioner had given a report on 24th of June 2015.
Yes, sir.
That the petitioner herein would not be entitled to. On the other hand, the say 3 persons, namely Sri Debeshwar Roy, Sri Someshwar Roy, and Sri Satyam Roy, would be entitled to the compensation in respect to the said amount. In respect to the, so would be entitled to the compensation. This court have also taken note of that these 3 persons have also initiated proceedings under Section 10 of the Indian Telegraph Act 1806,
my lord.
Huh?
Yes, Lord.
Not 1886.
1885, my lord.
1885. And in that regard, the learned civil judge Srirang have also passed a judgment and decree to the effect that the said three persons would be entitled to higher compensation. It is also brought to the notice of this court that these judgment and decrees so passed by the learned court of the civil judge Sirang have also been duly complied with by the respondent number 1 to 4. Under such circumstances, the question and be that as it may, in the year 2023, the petitioner has approached this court seeking compensation on the ground that the respondent numbers 1 to 4 had failed to pay the compensation. This court is of the opinion that these aspects, the questions which have been raised in the instant writ petition are disputed questions of facts which cannot be adjudicated in the instant proceeding. It is also relevant to take note of that the Indian Telegraph Act 1885 duly provides an adequate remedy in the form of Section 10 of the said Act to make necessary claim if the person is entitled to. And in the said proceedings, in the said forum, various disputed questions or facts can be very well adjudicated. Under such circumstances, this court is not inclined to entertain the instant writ petition on the ground of disputed questions of facts. Accordingly, the instant writ petition stands dismissed. Before parting with the record, this court, however, observed that if the petitioner is aggrieved as regards the amount to which the petitioner is entitled to, as regards the non-payment of the due compensation, the dismissal of the instant writ petition shall not prejudice the petitioner to avail the remedies available under the Indian Telegraph Act 1885.
Lordship, liberty may be given to approach before the district court.
What else did I say all this while? Yes, what are these? Same types. When did I fix it?
Second August, can it be on third, Lordship? Because SLP is listed before the Supreme Court on second.
Why? When did I fix the earlier matter?
Second August.
Okay. Third is Saturday. You want to come?
And on
We'll have it on second. Second, we are finishing it off. Unless these type of matters. At least the matter on second. Hey, I got order to assume that this is item number
21.
21. The same order, huh? 21 same order.
Great.
We'll come to know in the morning, SLP, what has happened.
Great.
We have the Lordship.
Yes.
But here, the petitioner's late husband has donated a plot of land for establishing in school, and in the gift deed, the private land in the gift deed, he has mentioned the school should be named after his father. That is the petitioner's late husband's father-in-law. Now, what happened in 2022, the school got amalgamated with another school, and it got shifted, and the name has changed. And the government has issued an impugn order dated 15/6/2023, which is at page number 52, directing the concerned authorities to establish the employment exchange.
What order are you challenging?
That is at Annexure 5 impugn order, where the government has directed.
Page?
Page 52. The school has to be, employment exchange was going to be established in the school.
So you donated this land for the purpose of a school?
School, and that is a condition in the gift deed that the school has to be named after my father. Now, what happened? The school got amalgamated with another school. The school got shifted, and the name also changed. So the condition is no longer there. So I want the one back the land as well as for passing this impugn order.
You want the land back.
Still in the private land, my lord, it is still the private land. It has not been transferred to the inter records. The government has got not immediately
How did you gift it?
by virtue of gift.
Registered.
Yes, sir.
Give deed, registered. Yes, where is the government? Yes.
We haven't got an instruction for affidavit also. Like, can it be some other time?
What is the interim order passed? So section Annex 5 has been stayed
Yes, ma'am.
for opening of an employment exchange. So have a employment exchange in his father's name? Have it? So and so employment exchange. Huh? Have it? Who does this employment exchange business? Which department?
Standing council. I'm told that there is a standing council for employment exchange. SP does.
And he is not here. You made the employment exchange a party.
Nothing with the party. DC is the party, my lord. The Hindu letter has been issued by the DC.
DC? What business does he have? We set aside that letter. Type of letters. How does the DC do all these things? Where is that document?
Page number 52, madam. Central DC in charge. Except 5.
Where is the stipulation in the gift deed?
My lord, the gift deed is in,
Where is the type copy of the gift deed?
yeah, my lord, page number 23.
Whereas feeling the need to establish an MA school at so and so.
Page number 24, my lord. Page number 24, first paragraph. Okay,
Page number 30.
Page number 24, my lord.
There are how many gift deeds?
3 gift.
Yes, where did it?
May I read it, my lord?
Yeah.
Page number 24. The school building, office, etc. must be on a donated land itself. After the elevation of the school, if the school authority wants to change its name, then the donor or his heirs will have the right to cancel the mutation of the school on the said land and take back possession of the land as per the terms and conditions of this gift deed. To this, neither the school authority nor the public nor the school committee will have the right to raise any objection, and if any objection is raised, the same will be null and void.
Was this gift deed accepted by them?
Yes, my lord, they have established the school there.
Huh?
They have established the school there.
Who signed? Who signed this gift deed? A gift has to be accepted. Has the gift deed been accepted by any authority?
Secretary Pendra Ranjan Sotartori, that is the-
Where?
At that point of time, the secretary was there.
Where is the signature? You gotta stay.
My lord.
So we do one thing.
You notary statement.
We issue a rule making it returnable after 10 years. It is noted this court have heard Mr. B. Chaudhary, the learned counsel, appearing on behalf of the petitioner. None has appeared on behalf of the Education Department on call. Mr. N. S. Bulwa appears on behalf of the Deputy Commissioner. Taking into account that the respondents have not filed their affidavit, list the matter on 6th of January 2025. Interim order passed earlier continues till the disposal of the requisition. Next. So why have you done all these things? Okay, Ms. P. Das appears on behalf of the 6th of January 2025. Name order passed earlier shall continue till the disposal of the record. Yes, Mr. Chaudhary.
Here in this case, this Karbi Anglong authority, my lord, they want to acquire Patta land without paying any compensation.
Oh.
And my lord, what they are doing, there were 7 petitioners. Some of them have some liquor shop, this and that. Now, because they have not filed the affidavit on one fee or the other, they are negotiating, my lord, coercing. And the present petitioner, number 1, whom I represent, he has some means to sustain, so therefore he has not agreed. And that peculiar stand has been taken by Karbi. And they should be taught what law is, my lord. With all respect, I am making this submission. Kindly see, in the earlier round of litigation, they said that no, earlier notice was, erroneously issued. So now we are recalling the notice. Now again they have issued the notice.
What notice?
For eviction. They are asking us to vacate the land, Patta land, because they want to widen the road. Because it belongs to their father.
Father?
Father of the my lord, authority. Limit to everything. Please come to page 27. Whereas the authority of Karbi Anglong Autonomous Council, DIFU, has taken up development projects along the road from so-and-so to so-and-so, measuring a length of 1.5 kilometer, whereas developmental work involves widening of the road and construction of flyover, whereas the reserve land of PWD measuring 50 feet of the either side from the middle of the road will be utilized in the interest of public service. Therefore, as per Assam Land Revenue Regulation, settlement rules, sections or rules, and so you are hereby informed to vacate the occupied land. These are Patta land, my lord. This is their understanding that from the central line beyond 50 feet, within 50 feet, it is their land. Lordship knows in a Patta there is a particular clause that if for repairing of the road, soil is required, then the soil, not land, soil will be taken free of cost. Now they want to read that here.
Where is your Patta?
Yes. But I'll just hand over a copy.
Not include?
No, it is there, but I'll just hand over one copy. Hey, come here. But it is in vernacular. The Lordship kindly comes to Sari, number 4. Ali Meramot Koribor Nimitte, District Council or Kajalor Okole, Unu Luksani Nidiakoi Hokolu Prodekio ba Lukole, Board Adir Kakhor ba Ukho Alir Namonir Pora, 35 ফুটৰ ভিতৰত খেতি সম্পৰ্কীয় মাটিৰ পৰাই কটাই আনিব পাৰিব আৰু সেই মাটিৰ বাবে তাৰ কোনো অংশ তাত থকা শস্য লগনি গছ বা ঘৰৰ মূল্যৰ বাদে আন কোনো লোকচানি নিদিয়াকৈ ল'ব পাৰিব. That means if for repairing of the road any soil is required, that soil can be taken. That's all. Beyond that, they have to pay the compensation. And there is one English version also, my lord.
Whether the rules, settlement rules apply?
Yes.
Applies, then what do you say about 23?
Rule 23, my lord. Roadside land. Nothing in this rule shall entitle any person to obtain a lease in respect of land within 75 feet of the center line of the public road. Any person occupying or encroaching on such land shall be liable to ejectment under Rule 18. Expression public road includes any road maintained by the state government or by local authority and any other road declared by the state government to be public road for the purpose of this rule. Except under general or special order of the state government, no new periodic lease shall be issued with respect of the land on chain of 75 feet reservation from the central line of the road maintained by the state government. That is restriction on my lord seeking lease on the land.
But if the lease patta has been issued
Patta is there.
in violation of the mandate of 23, 26 will come in.
True. No, my lord, our case is, we are not saying that this land is not liable for, acquisition. That we are not saying. If you want to build a flyover, certainly you can build and you can acquire my land. But for that, you have to pay compensation. How come you are issuing an ejectment notice, my lord?
Yes.
I have not filed the affidavit, my lord. My instruction is that out of the, my lord, 6 petitioner, the 2 petitioners has already sitting in negotiation, and they have already received the amount, my lord, offered by us for outright purchase of the land, my lord. And for respond number, petition number 2, 3, and 4, 5, my lord, negotiation is at the final stage. We are offering the amount, my lord, to the petitioners, those petitioners, and they are negotiation going on. Whatever amount they offered earlier, they rejected that amount, but new offer has already been made to us, my lord, or to them, my lord. So, my lord, so at least, my lord, 3-4 weeks time may be granted so that the negotiation, if we fail to on the negotiation of the paying the compensation for the to the 6 persons, out of the 30 people affected, my lord, all of them have already received a compensation. Out of only the 4 persons, the read petitioners, they are not yet to receive the amount, my lord. And the 4 petitioners, my lord, they are already sitting in a negotiable table between my lord with the authority of KSA, and it will be finalized within, my lord, some days, my lord. So 4 weeks time may be granted to us, my lord. That is my instruction, my lord, in writing, my lord.
No, but which means you are not adverse to giving compensation to the petitioner,
my lord,
for taking the land.
Now, for affecting, for damaging their land, my lord. And it is the, my lord, alignment of the PWD road, existing PWD road.
Very well.
The flyover is going on.
Whatever may be,
my lord.
But the issuance of notice, the Rule 18,
my lord,
would it be proper?
My lord, notice was issued on the ground that my lord, the 35 feet of the land, my lord, as per the Patta conditions, either they, my lord, and the settlement rules within 15 feet, they cannot construct the, my lord, any house, my lord. As there were certain constructions were there, my lord, so notices were issued. But so we'll put it on the affidavit, all these things.
Doesn't Rule 18 presupposes that it is a government land?
It is applicable in respect of the government land.
So how do we make Rule 18?
My lord, that alignment PWD road, existing PWD road is there, and after the within the 35 feet of the, my lord, side of the road, my lord, that road, as per the, my lord, instruction, my lord, that road is reserved land, my lord. So no construction can be made on that road.
No,
my
no.
lord.
If it is reserved, you couldn't have granted the patta.
But the condition is there that 35 feet we can take out the land from that 35 feet land
Only
for the
purpose of using the soil,
my lord, using the soil, whether that is the interpretation, my lord.
but not for any
repairing,
but
for repairing or for whether repairing includes widening.
no, you can let us assume you can go for widening
lord.
also. But widening also, this is if you have issued a patta to them, then this patta has to be, you have to acquire.
Regarding,
and when you are now entering into agreement with, have already entered into agreement of 2-3 persons,
my lord,
and why not with the petitioners?
with the petitioner, my lord, 3 petitioners has already agreed, my lord. Only we are offering the amount, they have to accept it.
Okay, so why not with the main petitioner, the one?
Only the,
Either you go ahead with the if he is not
Interim
interested,
order
you
has
go
already
ahead
passed,
with
my
the
lord.
acquisition.
The Lordship, interim order has already passed to maintain the status quo in respect of the land of the petitioner, my lord. So their interest has been protected, my lord, as the construction of the flyover is going on, my lord, and the other petitioners has already sitting in a negotiable table and they are agreed to it, my lord. Let us grant some time, my lord, 4 weeks time.
No, we do one thing,
My
we modify the interim order to that extent
My lord.
that if you want to go for acquisition, you go ahead.
My lord, my lord. If you fail to negotiation, then it is
Negotiate
difficult
with
to
the
go for
petitioner, you can go ahead with the acquisition.
My
Because status quo means you can't touch theirs also.
land, my lord.
Well, there is one only problem. These people are all living on hand to mouth. It's not that these are very influential people or something like that. Now, this notice and stay order was, status quo order was issued in November 2023. Now in July, every time when the matter is listed, my learned friend is making this very submission. Well, what they are doing, they are compelling us to enter into an agreement because many of them have lost their livelihood. This is the ploy which they are adopting, my lord. Let the CM give his own land for the construction of this thing, my lord. Why is he going after others' land?
Doesn't have a land there,
My lord, whenever any compensation is paid for land acquisition, CM's wives get the first cut. In one of the
Let us
cases, I
not,
appeared
let
before
us
court,
not
it has been
go
paid.
into that issue, Mr. Chaudhary. Let us make it very simple out here.
My lord, my humble submission is there should not be given any further time.
For what?
My lord, for filing affidavit because they've got enough
Not
time.
necessary, not
8 months.
necessary, and not necessary. But the fact that this land belongs to you.
Yes.
If it was a government land, it was a different thing. But
Yes.
Rule 18 notice could
Does not
not
apply.
have been issued. Yeah, it presupposes that it is a government land. What we do is this, let us record it down. Yes. Heard Mr. K. Chaudhary, the learned senior counsel, assisted by Mr. Ms. So-and-so appearing on behalf of the petitioners, and Mr. J. Sutia, the learned counsel, appearing on behalf of the Karbi Anglong Autonomous Council. That is the respond number 2, 3, and 4. To stop. This court have duly taken note of that on account of widening of the PWD road and for construction of a flyover, the respondent of the Karbi Anglong Autonomous Council have taken certain steps. And in that regard, had issued certain notices to the petitioners under Rule 18.3 of the Assam of the settlement rules framed under the Assam Land and Revenue Regulation 1886. This court today, Mr. J. Sutia, the learned counsel appearing on behalf of the KAAC, submitted that as regards 2 of the petitioners, the matter have been amicably settled. As regards the 3 other petitioners, the matter is on the verge of settlement, whereby the KAAC is taking steps for making due payment compensation to them as regards their land. However, it is this court also duly takes note of that as regards however, this court duly takes note of that Rule 18, duly takes note of that the learned counsel appearing on behalf of the KAC submits that the respondent authorities are also taking active steps for finalizing the issues as regards the other petitioners also. This court also takes note of that that the petitioners, more particularly, who is this person?
Well, actually,
This
we
patta?
don't have any instruction, my lord.
No, this patta.
This patta.
Is whose patta?
1 second. Name would be written there.
Patta of the petitioners are required to be annexed, so we have to patta it with them. So we could not, my lord, we have already asked them to submit the original patta before us, my lord. So it is required to be, my lord, verified, my lord, before this court or between
Wrong CD. Long kiri, I am holding, my lord. I do not know who I have given.
It is also taken note of that that during the course of the hearing, the learned senior counsel appearing on behalf of the petitioner has placed on record, before this court the vernacular version of the periodic patta issued to the petitioner number 1 and patta in respect to the full stop. The counsel appearing on behalf of the petitioner further submits that additional affidavit be filed to bring on record the patta full stop in question. Pattas issued to the petitioners in question. Full stop. This court also duly takes note of that if the land in question belongs to the petitioners, the action cannot be resorted under Rule 18 of the settlement rules, in as much as the settlement rules, in as much as Rule 18 presupposes issuance of notice only in respect to the rules which have been in respect to government lands, including land which have been reserved for roads, village grazing grounds, etc. Accordingly, this court fixes the matter again on 19th of August 2024. Full stop. It is also seen that there is an interim order to the effect that status quo be maintained. Status quo as of now shall be maintained till the next date fixed, which have been extended from time to time. This court duly takes note of that in the circumstance the respondent authorities wants to take any action against the petitioner, the same can be done so by either by negotiated settlement or by acquisition in accordance with law. As such, the negotiated and as such the status quo order so passed, which is also further continued till the next date, is shall not in any manner interfere with the right of the KASC to enter into a negotiated settlement with the petitioner or to carry out acquisition in accordance with law. The instructions submitted by Mr. J. Sutia, the Learned Counsel appearing on behalf of the respondent number 2, 3, and 4 is kept on record and marked with the letter X. I think this will solve your problem.
Yes. Otherwise, I have some problems.
What is this?
Surplus land, without really paying any attention. The respondent already demolished the house on 22. That's not called for.
What order? What are you challenging?
This 80.
What has happened?
Already affected lordship.
Huh?
Already affected lordship.
Evicted. Then nothing remains.
Proper compensation lordship. Not paying any proper compensation lordship.
Yes, petition has been evicted from it's your land. Filling surplus land.
Petitioner alleges that my lord, she was in occupation of a plot of land, which is a selling surplus land. And at the same time, petitioner, my lord, also says, if lordship may be pleased to come to paragraph 16 at page 15 of the writ petition.
Yes.
Petitioner begs to state that a motto of the Urban Sealing Act was violated by the respondent authority. Respondent authority, without conducting the zirat and pay proper compensation, they have evicted the petitioners from the house and destroyed the valuable property of the petitioners. But very surprisingly, the respondent authority paid only an amount of rupees 5 lakhs of the Assam type house and rupees 10 lakhs only for the RCC house. It is to be mentioned that the petitioner's Assam type house was already demolished by the respondent number 5, and RCC house was partly demolished and already paid an amount of rupees 10 lakhs to the petitioner's account. But without paying any proper compensation, it is very much arbitrary in the part of the respondent. Now, the prayer portion, Lordship, will see at page 17.
This is in where? Where is the land?
It is now, my lord, circumscribed within the Guwahati Water Bodies Act.
Okay.
So it is, my lord, there is a statutory bar. And we
Now,
have-
if the petitioner wants more compensation, then where will he go?
have to file a civil suit. He will have to file a civil suit.
Is there a bar under the Water Bodies Act?
Apparently, there is no bar.
Water Bodies Act.
Well, it is a part of the writ petition. That
Page
lordship will find at page
Page-
40 onwards. Page 40.
40 almost.
If lordship may be pleased to come to page 41, my lord, section 4. Notwithstanding anything contained in any other laws enacted by the state legislature, which are for the time being in force in Assam, the area of land specified in the schedules of this act shall
Under 8.2 is a bar.
My lord, 8.2. No suit, prosecution or other legal proceedings.
No,
shall-
next,
No,
8.2.
no suit or legal proceedings shall lie against the government for any damage or injury caused or likely to be caused to any owner or person in pursuance of this act, which is done or intended. Yes. There is a bar. And we have received the instruction. Instruction also says that, my lord, that 5 lakhs has been, my lord, paid for, my lord, damage caused to the Assam type house and rupees 10 lakhs for the RCC building.
What is the valuation of the house and building? Have you enclosed out here?
No, my lord.
No loans.
Then how will this court come to any
They have
finding?
not,
Tell me.
they have not survey loans.
Huh?
They have not survey loans. And no GR has not.
Understood. Did you make any survey? What was the valuation? You file your affidavit only to that extent regarding the compensation.
Yes, compensation we have received, my lord. The instruction is
No, you
also
have given 5 lakhs and 10 lakhs.
10 lakhs.
In general loans. In general.
You have got the money. 5 lakhs also.
Also.
No, only 10 lakhs I have received. Also.
No,
No,
no.
no, here you say in your paragraph itself.
They have paid 5 lakhs for Assam type house. 10 lakhs for RCC building also. And I have received only 10 lakhs also.
You have not received the 5 lakhs.
Yes, Lord.
No, but you see, but very surprisingly, the respondent authority paid only an amount of rupees 5 lakhs only for Assam type house and 10 lakhs. It is to be mentioned the petitioner house was already demolished and was partly demolished and already paid rupees 10 lakhs, but without proper compensation. So you categorically say that you have been paid.
He has, petitioner had constructed an RCC building over there.
And an Assam type.
Assam type, my lord, Assam type, he says that, my lord, my instruction says.
With photo I have filed affidavit also.
The counsel appearing on behalf of the petitioner submits that the petitioner have that the respondent authorities in pursuance to the eviction carried out had demolished the Assam type house as well as the Assam, as well as the RCC house. The case of the petitioner that the petitioner have received 10 lakhs on account of the RCC building, but however have not received 5 lakhs. Full stop. This submission so made seems to be does not appear to be in consonance with paragraph number 16 of the writ petition. Under such circumstances, the petitioner is directed to file an affidavit clarifying the statements made in paragraph 16 of the writ petition. List the matter again on 19th of August 2024. The affidavit will be filed in the meantime.
Happy. Well, I can also bring my instruction on record by filing an.
The respondents are also at liberty to, the respondents shall also file their response in the meantime.
I'm so
Have
obliged.
received the copy today, Miller. Have received the copy affidavit in opposition filed with the respondent.
Affidavit.
Filed.
Then
Sometime may be given to file objection.
you want to file a reply. Ms. S. Roy, the learned counsel appearing on behalf of the petitioner, submits that the affidavit filed by the respondents have been received today. She would like to file a reply. This is the matter after 4 weeks. For 4 weeks time is granted in that regard. This is the matter on 4th of September, 6th of September 2024.
31.
I would like to file a reply to the affidavit opposition.
The matter about
Petitioner's land minor, over the petitioner's land minor, the pipeline is sought to be laid minor. And ordered a compensation amount has been determined, minor. Now, the compensation amount is not being disbursed.
not paid, 13 lakhs. Yes, why haven't you paid?
My lord, actually, we have taken the jurisdiction point, my lord, under the Petroleum, my lord, and Minerals Pipeline Act 1962. It is a district judge, my lord, who has to determine the compensation, my lord. But in case of my lord,
Who has determined the 13 lakhs?
by competent authority.
Huh?
No, that has not been reflected here in the I filed my affidavit in opposition lordship. Competent authority has to decide the compensation part. And if there is dispute, my lord, if lordship may see the affidavit file, paragraph 4 of the writ petition, my lord. Objection, my lord. Who is the cousin or brother of the petitioner, my lord.
Mr. P.K. Munir, the learned counsel appearing on behalf of the petitioner, submits that he would like to file a reply to the affidavit in opposition. This is the matter after 4 weeks, 8 to 6th of September. 6th of September, in the meantime, the affidavit in reply.
My lord is fixing a date. The date.
6th of September.
Deeply obliged. 32.
Yes, my lord. Our house was situated, my lord, nearby border, my lord. Due to fencing, my lord. My land was taken as subsidy, my lord. I was not in there.
What is this?
This case, my lord.
Huh?
I was living, my lord, near the border area. However, due to fencing, my lord, I could not stay here. Subsequently, my lord, I was driven away by the BSF personnel because I was near the fencing. And now I'm staying in a rented house. My husband is expired. Now I'm seeking a land from the government, my lord. So whether any alternate land can be given or not, my lord. And now I'm a landless person, my lord.
You have filed an application for settlement?
Application.
When?
Before the district commissioner
No. There is a manner in which you file your application for settlement. How? Mr. Barbuzari? Mr. Barbuzari? How do you apply for settlement?
There are two modes right now. One can apply through Vasundhara. Now Vasundhara 2 is now upgraded. It will be, my lord, made available to the citizens shortly. That way they can apply, or otherwise, my lord, they will have to file the application in proper Kabula form. That will have, my lord, the person concerned
To whom?
before the circle officer.
Circle officer or deputy commissioner?
Either before the circle officer or before the deputy commissioner. Also, it has to be addressed to the deputy commissioner. In fact, the format itself is prescribed, my lord.
Yes, not in this manner. Mr. Counsel, not in terms with 17.
This case, my lord, I am a widow, my lord. Widow with an illiterate native. Widow with 5 children, my lord.
Widow can approach you. So you advise and fill up the form in a tabular form and ask her to file it properly. There's a manner in which you file the application. Hello. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Arbor Pujari appears on behalf of the Revenue Department of the Government of Assam. Mr. B. Chakraborty appears on behalf of Government of Assam. Revenue is there, however.
Yes, my lord.
Mr. B. Chakraborty appears on behalf of the respondent number 1. Who appears for 3 and 4?
5, 6.
3, 4, and 5. Ms. S. Borua. 5 and 6. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities, more particularly the respondent number 1, 2, and 5 in granting settlement to the petitioner in respect to a plot of land as the petitioner had duly applied. It is the case of the petitioner that the petitioner, along with her husband, who used to reside in the border area. However, on account of certain actions taken by the BSF authorities, the petitioner were removed from that area, and as such, the removed from the sale. Subsequent thereto, the petition.
Not done by yes.
But he says so. And as such, pursuant thereto, the husband of the petitioner had expired, and as such, the petitioner had submitted an application on 6/3/2023 in terms with the land policy of 2019 before the Deputy Commissioner Karimganj for allotment of a plot of land for residential purpose. It is seen Mr. Arbapura appearing on behalf of the respondents, Revenue Department submits that for filing an application for settlement, the same can be done in either by way of applying through the Vasundhara 2 portal, or by way of filing an application in a tabular format to the Deputy Commissioner of the concerned district.
Concerned district informed white form number 125 and 126.
White form number 125 and 126.
Yes.
So the learned counsel appearing on behalf of the petitioner submits that the petitioner you would duly file the necessary applications in the manner in which it is prescribed. Taking into account the above, the instrument petition stands disposed of thereby granting the liberty to the petitioner to file appropriate applications seeking settlement of land in terms with the land policy of 2019, either through the Vasundhara 2 portal or by filing application to the Deputy Commissioner in the proper format. It is observed that in the circumstance that petitioner submits such an application, the respondent authorities, more particularly the Deputy Commissioner Karimganj district as well as the Revenue Department of the Government of Assam, I think revenue department would not come. Nowadays, you,
Has been delegated to the district commissioner.
the district commissioner, Karimganj district shall duly consider the case of the petitioner in accordance with the land policy of 2019 and dispose of the said application.
And apart from that, if there is no anything available in the land policy 2019, then also, my lord, I am seeking taking the alternate land and the house from the government. If there is not any scope within this land policy, then maybe deputy district commissioner may be permitted.
You are a landless person,
Landless person,
indigenous,
indigenous.
don't worry.
33.
Yes, what is this?
Regard to non-payment of the Zafar money.
Huh?
Petitioners are the beneficiary of Prime Minister Sabas Yojana. They were sanctioned with some amount. This 1 lakh.
Total amount of 1,50,000 was sanctioned in favor of the petitioners by the government as per the PMAYG scheme. 1,30,000 has already been disbursed to them. They have withdrawn the funds. The remaining 20,000 amount which is pending, Millet, their allegation is that amount of 20,000 has been siphoned off by certain ex-members of the Gaon Panchayat. They accordingly filed an application before the Superintendent of Police at page 134, my lord. What action now the police?
Page
134, my lord.
And
So whether they have registered an FIR or not is something which the petitioner would be.
then what happens?
Action, whether it has been taken or not by the police is something the SP would be able to disclose before this court. I'm for the Panchayat department.
Besides that, we also submitted an application before the respondent number
Has
3.
this been registered as an FIR?
No, Milord.
He has not done that.
No,
Why wouldn't you file an FIR?
no, Milord. This the application that has been referred to, Milord, it pertains to some other beneficiaries, Milord, but not the present petitioners. We submitted an application before respondent number 3. Your lordship will find at page number 56 and extra 6.
56.
Milord.
His specific allegations are against 1, 2, and 3, which is at page 1.
This is our application, Milord, we submitted before respondent number 3. That is the block development officer. That is the BD. 17/10/2023, we submitted an application. No action was there, Milord, and therefore we are before your lordship.
You want the 20,000?
Milord.
Who has taken the money?
Milord,
The ex-president of the Mahatoli Gaon Panchayat.
the president and then the member, ward member, as well as Milord, the GRS. The
So your
person-
allegation is of misappropriation.
Misappropriation.
Then why are you not filing an FIR?
To dispose of
File an FIR before the appropriate authority, before the appropriate police station. What is this court going to do? File a CBI inquiry.
Milord.
What?
No, Milord.
Yes.
I am not on that. Because Milord, some other beneficiaries, Milord, they submitted a FIR before the superintendent of police, Milord, but no action was done, Milord.
You file it.
Milord, if your lordship directs, then we will.
Go and file.
Milord.
Okay.
Milord.
The petitioner herein is aggrieved by the inaction on the part of the respondent number 3 in taking steps to take action against the various private respondents herein who, as per the petitioner, had misappropriated an amount of rupees 20,000 to which her mother, the petitioner's mother, is entitled to.
There are some other, there are 5 petitioners, Milord. The petition number 1 and 2, Milord, claimed the money of their mother. Mother is the beneficiary. And petition number 3 is the husband of the beneficiary. And 4 and 5 is the beneficiary by themselves. I have made the statement, Milord, in paragraph 3.
Who is entitled to?
Milord, in fact, the beneficiary is the mother of petition number 1 and 2, Milord.
What is the name?
Name is Milord,
Basumia. Huh?
Your lordship will find at page number annexure 1, my lord, series. I have.
Who is the beneficiary, Mr. Counsel?
Beneficiary is Bhanu Nesa, one Bhanu Nesa is there, my lord.
Where is Bhanu Nesa? He's not a party.
Her, yeah,
He's dead.
no, she's alive.
Then why all other people are filing? So many people are filing for 20,000?
Because they have also not obtained their money. Beneficiary is separate and individual.
No, you are concerned with whose money? Mother.
Mother of petition number 1, mother, then the money of mother of petition number 2, and the money of the wife of the petition number 3, and 4 and 5 beneficiary by themselves. They were individual beneficiary, my lord. Your lordship.
So they are entitled to certain amounts,
My lord.
which were misappropriated by the private respondents.
Respondents.
The petitioners herein have approached this court by filing the instant writ petition to draw the attention of this court that the respondent number 3 have not acted pursuant to due representation by the petitioners about misappropriation of certain amount of money by the private respondents. It is the opinion of this court that the petitioner would be well advised to take appropriate steps by filing respective FIR before the concerned police station having jurisdiction over the matter. It is observed that in the circumstance such FIR is filed by the petitioner, the concerned police station shall duly act in accordance with law. Above the petition stands exposed.
Right.
34.
Again, same.
No.
Oh.
This is with regard to the conversion of the status of the land, my lord, of the present petitioner. Your lordship may kindly peruse annexure 8, page number 39.
Yes, what has happened?
My lord, the land was the patta land, my lord, and it was duly purchased by the grandfather of the petitioner.
Then?
Subsequently, there was a cadastral survey, my lord. So, wherein, my lord, the tag number were, my lord, changed. But the fact that the earlier tag number was not connected with the new one, my lord, the status of the land was shown to be a government land, my lord. So, it has been converted to, my lord, in the revenue records, my lord. It is shown as a government land.
Your land?
Yes,
The petitioner filed an application.
Yes.
Second option.
In fact, 3 DAGs were created, my lord, in the new DAG, and one of the DAG, my lord, one bigger has already been again, my lord, made it.
Required formalities are initiated, Lordship.
Report the name of Sarban during resettlement DAG number. The petitioner herein being aggrieved by the action on the part of the respondent authorities in making the patta land a government land by during the cadastral survey carried out, has approached this court by filing the present writ petition. Today, Ms. Esbulwa, the learned counsel appearing on behalf of the district commissioner, Dhubri, submits that submits on the basis of instructions issued by the additional district commissioner bracket revenue Dhubri that apparently there was a mistake which was committed by the concerned officials in making the land in question the land in Dag number 618 in question as government Dag, as government land. Pusto. This court had also perused the instructions which have been placed before this court. The said instructions is kept on record and marked with the letter X. From the said instruction, it appeared that Dag number 618 was earlier recorded in the name of Srimati Sarbana Bibi, wife of Muksid Ali Sheikh. It was also mentioned that during the resurvey settlement operation, two Dag numbers, namely 2356 and 2357, were created out of old Dag number 618 of Revenue Village Sopata Part 5. However, the newly created Dag numbers, that is Dag number 2356 and 2357, is recorded as government land as per the land records due to old Dag number was not linked with the new Dag numbers during the cadastral survey of the village. It is also seen from the instruction that while matching of the trace map of the said area, it revealed that the area under the newly created Dag number 2356 and 2357 is a part of the land of old Dag number 618. This court, it is also stated that the government authorities are taking due action for making necessary correction after verification, etc. Taking the said instruction is kept on record and marked with the letter X. To list the matter on 2nd of September 2024, on which date the District Commissioner Dhubri shall further apprise as to whether the corrections which were to be carried out in terms with the communication dated 28th of May 2024, which is kept on record and marked with the letter X, have been duly made.
35.
35, 36, your lordship. These are people already evicted, your lordship.
Huh?
2051, they were evicted, your lordship.
Evicted? Then what remains?
Further, your lordship. Now, your lordship, ultimately, your lordship, for them, your lordship, if your lordship comes to page 53, your lordship.
53.
53. This is the judgment of the PIL, your lordship. 54, para 4, your lordship.
Yes, what is this?
Now, your lordship, thereafter, your lordship, since rehabilitation has not been done, your lordship, therefore they came before this honorable court by filing these two writ petitions. So far as the other petition is concerned, your lordship.
Rehabilitation for what?
For your lordship, for after evicting these people, your lordship, then your lordship for alternative land, your lordship.
They were in what land?
Government land, your lordship. Those were all government land, your lordship. They were evicted. What had happened, your lordship? There was a your lordship will kindly come to page 40.
Yes.
This is the minutes of the meeting, your lordship.
This is Gorukuti. How many people evicted?
Around 2,000 families have been evicted, your lordship.
2051.
Lordship. Now here, your lordship, thereafter, your lordship, they are still, in fact, your lordship, they are in a camp, your lordship, this group, your lordship, this group, your lordship.
They are still in the
This
camp.
Camp, and few days back that has also been evicted by the revenue authorities, your lordship. Now, your lordship, they have nowhere to go, your lordship.
Yes, yes. What is happening? Revenue. You are the person who have done all this. Why no affidavit has been filed? It has been long time back. Notice was issued.
My lord, we have communicated.
Huh?
We are awaiting the instructions, my lord.
No, await instructions for such a long. On one hand, you are throwing them out and you are still awaiting instructions. There's a plight. It's a serious question. Two thousand 51 families have been evicted. The serious thing.
Yeah. Supreme Court of 54.
Because page 41 of the writ petition, it speaks about a committee.
Understood. Whatever may be that the High Court, the Supreme Court has passed an order on 11/8/2023. We are in the month of, we are reaching 11/8/2024 in another week's time.
Yes.
Therefore, the instant writ petition has been filed by a group of petitioners seeking rehabilitation. From a perusal of the materials on record, it is seen that on 28th of September and 23rd of September 2021, various families were evicted for the Gorukuti project. A PIL was filed in that regard. And the said PIL, which was registered and numbered as PIL number 65/2021. The said PIL was disposed of. With directions for the persons who are aggrieved on account of not being granted rehabilitation to represent before the Deputy Commissioner, and who, after due hearing, shall pass appropriate orders. After 7 months, a special leave petition was filed which was registered and numbered as special leave petition civil diary number 17161/2023. And the same was disposed of by an order dated 11/8/2023. Paragraphs 2 to 3, 4, and 5 of the said order being relevant is reproduced herein under page 54 of property. It is seen from the above quoted paragraphs that the Supreme Court had expressed concern about the inaction on the part of the respondent authorities expressed concern as regards the rehabilitation to be carried out. Mr. Bhattakur, 600 families have been rehabilitated.
There's 10 billion out of 2050 billion.
It was observed by the Supreme Court that any affected individual having any grievance in respect to rehabilitation can approach this court, highlighting the grievance which remains. It is under such circumstances as the petitioners herein have not been rehabilitated in spite of having approached the concerned respondent authorities. The petitioners have approached this court by filing the instant writ petition. The record reveals that on 22/3/2024, notice was issued a response have been received either from the Revenue Department of the Government of Assam or from the District Commissioner. The plight of the petitioners, in the opinion of this court, have given rise to a human problem. And it is expected that the respondent authorities, being a welfare state, is required to take appropriate steps at the earliest. Under such circumstances, this court fixes the matter again on 12th of August 2024. The respondents, more particularly the Revenue Department as well as the District Commissioner Dorong, shall file their respective affidavits by bringing on record the status of rehabilitation of the persons who have been evicted and what further steps are being taken for taking care for rehabilitation of the other persons who have been duly evicted. List accordingly.
Next case, this order will cover next case. Notice was issued on the same day.
We put it, list the matter, the next one, list the matter along with this on this date. Because their affidavit will overall contain everything. Next matter to it would be list the instant writ along with so and so on this.
right to fair compensation 2013, my lord, the section 65 describes my lord, about certain limitation for making an application by the aggrieved person. The minimum limit is, my lord, 6 weeks first. Thereafter, my lord, if required, then another 6 weeks may be extended, but it should not be outer limit of 1 year. Therefore, my lord, it is crystal clear that the limitation period is a significant bearing entire this process. But here in this case, my lord, this has been.
Who are you?
My lord, I am the person, I am the authority who has acquired the land, Assam Industrial Development Corporation, and my lord, out of which now the aggrieved person approached before the, my lord, Deputy Commissioner, District Commissioner, for referring this matter to the, my lord, reference authority, my lord. Now, in this process, my lord, what happened after the belated stage, my lord, the approach was made. And even that approach was made, my lord, in
Reference made?
My lord, Deputy Commissioner referred this matter to the, my lord, authority concerned for such decision, my lord. Now, question is that, my lord, section 65 clearly say that it must be in consonance with the limitation which has been prescribed there. That is, the application must be preferred from the date of award within, my lord, 6 weeks first. Thereafter, my lord, another 6 weeks, and thereafter outer limit is 1 year. That is subject to the satisfaction of the district commissioner. But if we see, my lord, is that not only in this case, but numbers of cases, my lord, one go to schedule to the concerned person, even it has not reached to the deputy district commissioner, my lord. Straightway, my lord, by endorsing the number, it has been referred to the, my lord, next authority for this, my lord. Second aspect of the matter is that, my lord, the order required to be challenged is award. Lordship can say there is no award which has been, my lord, annexed with that, my lord, particular. In terms of, my lord, rule 2015, form 15, form 10 is the award, my lord, which has to be put under challenge.
No.
Yes, my lord.
No.
Award one of section 23 can say.
No, award has not to be challenged.
Yes, my lord. Language is very much clear.
Language, whatever may be the form, it is immaterial.
But because, my lord, that award contains the entire scenario of, my lord, compensation, area of land, everything, my lord.
Go and raise out there before the collector. Nothing doing.
My lord, we cannot raise, my lord, because the reason behind is that the matter has always.
First of all, it is the fault of them. They have referred it lately.
Yes, my lord.
Then how does it matter?
My lord, question is that, my lord, the deputy commissioner entrusted with the duty to take into consideration the limitation part, which is, my lord, paramount in this entire scenario, my lord. A person cannot come in the, my lord, indefinite time, my lord. Therefore, my lord,
that can be an issue which can be raised before the reference court.
We cannot, my lord. The reason behind is that, my lord, the reference court will only look into the application which has been made thereafter. Prior to that, my lord, the segment of, my lord, limitation has to be tested by the deputy. Lordship can see for a moment section 64 clearly indicates, my lord, what is the duty cast of it.
Right to fair compensation.
Right to fair compensation.
Yes, right. You have it with you?
Yes.
Second copy.
But the word is very much clear, satisfaction, my lord. The word is very much incorporated satisfaction of the district commissioner, my lord.
Satisfaction is there.
But there is no reference, no, even there is no pleadings.
We are not going to see this content.
When there is not a single whisper in their own application, my lord, why delay has been caused? My lord, page 64. Provided that every such application shall be made, person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. The word is very much clear. Thereafter, my lord, second part is another 6 months, and third is, my lord, 1 year. And thereafter, my lord, 65 also indicates the collector's statement to authority. Nothing is there, my lord. Simple application which has been made by the applicant that has been stated referred to the, my lord, to the authority concerned, my lord. That if suppose this process will be conducted, then, my lord, it is a clear-cut case of bypassing of the section 64 and 65, my lord. The word is very much award. And lordship can see that application for page 18.
Where it says that the award has to be challenged?
My lord?
Where does it say that the award has to be challenged?
Language itself shows.
No, read it. Read it. Any person interested who have not accepted the award may by written application to the collector required that the matter be referred to the collector for determination of the authority as the case may be, whether his objection to the measurement of the land, the amount of compensation, the person to whom it is payable, the right of rehabilitation, resettlement under so and so, or to the apportionment of the amounts here.
Therefore, the first line is very much, if any person intends who has not accepted the award.
Yes.
So therefore, award is, comes from,
these things.
Award comes from, Form 10, which is the part of, act.
Nothing doing. Land acquisition proceedings of LA, yeah. When was the land acquisition proceedings award passed?
What was passed, that is not a clear cut of date given by the applicant.
Oh, when the award is passed, where's the award?
Yes, page
Page
18 of their application. It
No,
starts
when
from
was the award passed?
page 20.
See, 9th of February 2022, section 6(1) notification was passed under the Assam Land Requisition and Acquisition Act. Then why are you coming into this 64?
Reason behind is that,
Why are you coming into 64? 64, why do you need to come to 64? Because section 12 does not contain a limitation. Come, where is section 12 says about limitation?
Land acquisition.
Absolutely.
That's why, if it is a case of land acquisition act, there is no case. There is a case of comes under the Rehabilitation Act,
It's
2013.
nothing to do with rehabilitation. This is being acquisition done under this act.
Exactly,
This is the notification issued under section 6.
Yes, madam.
This is not done under the new act.
Kindly see for a moment.
No.
Nothing. I make it clear, madam. What is the award?
Yes. How much cost? No. Today I have not imposed any cost. 10,000. How many petitioners are there?
Government.
An authority is abusing the process. So we make it 10 lakhs each.
My lord, the
10 lakhs.
clarification
No,
is
the
for
cost is 10 lakhs. You have got to stay.
what is the
Nothing
clarification?
doing. No, nothing doing.
But the respondent has been
Yes.
directed.
Spoiling the judicial time of this court.
Directed to last instruction.
Not necessary. We don't need their respondents anything.
They
We
have-
don't need anything. This is done under section under the Assam Land Acquisition. Yes.
My lord, just my lord,
Therefore-
when award was passed. my lord.
Therefore, the instant petition has been filed.
Only one submission.
No, nothing doing. Heard Mr. S. Samoria, the learned counsel appearing on behalf of the petitioner. Anybody appearing? Government?
He will appear for. Instruction was sought for, my lord.
Not necessary. I'm just putting them the name so that they get the fees. Nothing more than that. Okay. S. Burwa appears on behalf of the respondent number 1. And Ibu Dokane. And why are you making the additional district judge a court?
My lord, no, that is mistake, government. They are.
Yes. The instant writ petition has been filed by the petitioner. Challenging the reference being made by the respondent number 1 to the court of the district and session judge Kamrup for in terms with section 12 of the Assam Land Requisition and Acquisition Act 1964. It has been challenged. The acquisition proceedings have been challenged before this court on the ground that the same is beyond the period of limitation as stipulated in section 65 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. This court duly takes note of section 12 of the Assam Land Requisition and Acquisition Act 1964, which does not stipulate any period of limitation. Under such circumstances, the instant writ petition is misconceived and accordingly stands dismissed with cost and thereby imposing exemplary costs to the tune of rupees 5 lakhs.
My lord, I kindly see, my lord, I may be allowed to withdraw.
Dismissed courage. Interim dismissal like goodness. The limits of filing writ petitions. You see, there is only one judgment. I tell you why I know this thing. There's only one judgment of Justice H.K. Sharma when he was in the Supreme Court, wherein he dismissed it on the ground of limitation and said the Limitation Act cannot be applied to rule section 18. But thereafter, from 2019, 2018, 2019, 2021, there are many judgments of the Supreme Court say you cannot take away the right out there. And here's 12, there is no limitation.
But my lord, it is not a case of my lord challenging.
Again, here same matter.
That
Same. Okay. You are withdraw or dismiss?
Yes, both my lord.
আগৰ অৰ্ডাৰটো নিচিনা লিখি দিম dismiss. নম্বৰটো খালি লিখি দিব হা LA case number so and so.
Your lordship.
Ah.
Lordship, can the matter pass over for the day, lordship?
My lord, the matter has become infectious, my lord.
Oh.
Regarding replacement room, we have taken position. We have a, my lord, issued a fresh tender also. Because this honorable court did not pass an interim order, they filed a writ appeal. The appellate court wanted to dismiss it, then they would do it. I filed, my lord.
Writ appeal withdrawn.
Withdrawn. My lord, I filed the affidavit, annexing the copy of the writ appeal.
Then? Agenda for what?
At some point to argue in this matter, lordship.
Already tender.
Earlier, did I pass any judgment in this case?
Already taken possession of the replacement.
Possession taken.
Taken before the writ appeal, my lord. Affidavit in opposition, we have annexed the writ appeal.
Oh, yes, I remember. My case only.
Yes.
Ah, writ appeal withdrawn. Nothing.
Come in factors now. And they have not taken part in the request.
After the matter was heard at learned counsel, we have sought leave of the court to permit withdrawal of the special with a liberty to approach the High Court by filing review petition in respect of the right of renewal. Okay, then review petition filed.
No. Then file lead petition after 1 year, my lord.
Is there any interim order?
No interim order will pass. That is why they went to writ appeal. But before that, we have got the position of the replacement room. And we are the same
not
and
able to
the
show
tender.
a good cause for remand. Now your the tender is going on.
Tender, yes, my lord, scrutiny, under scrutiny.
Joint report,
Already
we
technical
understand,
details of
conduct the journey of the joint remand regarding closure and ensure the referral has been closed on remand and there was no outstanding dues against the refreshment of remand. The following details, so and so. This is for yeah. So nothing.
My lord, as per my instruction, in some divisions, apart from longer divisions, the railway department has substituted the refreshment room by some tea stores or something. So on that point, my lord, my senior wants to argue this matter. Court date may begin for a week, my lord.
Hello. Please, at the request of the learned counsel for the petitioner matter stands adjourned to be listed again on 31st of July 2024. Mr. G.N. Sahewala, the learned counsel appearing on behalf of the learned senior counsel appearing on behalf of the IRCTC submits that the possession of the petitioner's stock have already refreshment room have already been taken by the IRCTC and the same and tender has also been issued. Tender issued.
Issued, my lord. On 13/6 and technical bid open on 11/7.
On 13/6/2024 and technical bid has already been opened. Full stop. It is made clear that the pendency of the instant writ petition shall not bar the Railway Authority IRCTC to take steps for settlement of the refreshing room in which. Yes.
The GST matter, Lordship, the scheme of the act is that after the scrutiny is conducted, the audit is, may be taken by the respondent authorities.
Huh?
Audit may be conducted after the scrutiny is completed. That is the scheme of the act, Lordship. In this case, Lordship, they have completed the audit. They have given the findings. I have accepted it. I have paid it off. Now they have come up with scrutiny.
So you say that there cannot be a scrutiny after audit.
Lordship will peruse section 61 and section 65 of the Act. Lordship.
What does it say? Yes, what is this?
We need to obtain instruction, Lordship.
Why you have not been able to obtain instructions? Huh? Why? Who does the audit?
Lordship, the GST authorities.
GST has done this.
Yes, the audit has been done by the Assistant Commissioner Lordship, and now the scrutiny is being done by the Superintendent, who is a lower authority to the Assistant Commissioner Lordship.
Audit report dated so and so. Which order you are challenging?
I am challenging Lordship page 27. Page 27 is a form ASMT 10 which is issued
Shall
under
not
section
be
61
entitled to
Lordship.
take it in respect
Regarding
of
scrutiny.
invoice or debit note. Then why you are not replying? You have replied to this notice.
Audit already conducted.
Huh?
Audit already conducted.
Well,
After
understood.
that,
Why
they
you are not
started
replying?
And moreover, as
Mr.
submitted-
Sarah, why you are not replying to this in the communication?
Lordship, there is an instruction of the state government which says that where audit has been conducted.
I am not concerned with that. Why don't you point out that instruction before that authority concerned?
Lordship has submitted.
This report approach this court.
Lordship has
Go
submitted.
there.
Lordship has submitted.
I
in
am
the
not
morning
going to
today.
do it. No, nothing doing.
One more submission. Last
No,
submission,
nothing.
Lordship.
Absolutely nothing.
Lordship,
Go
we
there.
peruse that page 27 is again on the point of section 16(4). And as submitted
Whatever
in the-
may be, why are you not replying to that? You reply. Any action taken, you will be obviously you can do it. Nothing doing. Against the notice, my goodness, the limits.
Lordship, if it may be fixed on Friday, just like.
Now. I'm passing an order now. Just now,
Lordship,
finishing it off.
tomorrow the budget will also relax this case
Very well.
on Friday, Lordship.
You go and reply. By the time I give you 7 days time to reply. So by the time budget will come and relax it. Matter who. Heard Mr. D. Saraf, the learned counsel, appearing on behalf of the petitioner. None appears on behalf of the central excise, on behalf of the CGST on call. Full stop. The instant petition has been filed by the petitioner challenging the notice dated 23/2/2024, whereby the superintendent CGST Nagaon range had asked the petitioner to submit an explanation
Page 28, Roman 1, Lordship.
submit an explanation as to why the ITC amounting to rupees 1781171, which was availed by the petitioner after due date, should not be returned to the department. Full stop. Mr. D. Tharab, the learned counsel appearing on behalf of the petitioner, submits that once the audit have already been carried out by the assistant
Commissioner of State Tax.
commissioner of GST,
Lordship.
CGST,
Lordship.
the question of issuance of a notice dated 23/2/2024 does not arise. He further submitted that as regards the instructions dated 31/10/2023 issued by the
That is Delhi instruction.
that
Lordship.
is
This
nothing
the
to
Assam
do.
instruction.
Huh?
This is the Assam instruction.
He further submitted as regards the instructions issued
Point number 3 and 4.1.
by the government of Assam, by the Principal Commissioner of State Tax Assam,
clause 3 and 4.1.
dated 26/12/2023 and draw special reference to clause
Para 3.
and special reference to clause 3 of the said in the instructions.
4.1 also, Lordship.
And
4.1,
where is 4.1? There is no 4.1.4.
Lordship, the first point, the sub-point 1, Lordship.
In those cases where audit proceedings have been completed, the notice against giving issuing of IT where software needs to be dropped. That was clause 1 and 3. I refer to clause 1 and 3. Full stop. This court is of the opinion that these aspects of the matter could be very well brought to the notice of the concerned respondent authorities, that is the superintendent, CGST Nagaon range, by submitting a reply to the communication dated, to the notice dated 23/2/2024. Full stop. Accordingly, the instant petition therefore stands disposed of, thereby granting 10 days time from today to the petitioners to submit the reply against the notice dated 23/2/2024, highlighting the various grievances as well as regards the instruction number 13/2023 GST dated 26/12/2023. It is, however, observed that in the circumstance the petitioner is aggrieved by any action taken by the concerned authority, the petitioner would be able to avail remedies which have been duly provided in accordance with law. You take this, you may require the number to huh? We keep it. Yes, Mr. Solia, your matter. You have mentioned as regards the transfer petition, na? The transfer petition we have not disposed of. This court had not withdrawn the transfer petitions. Only the IA has been disposed.
But obviously, both the matters are disposed of.
Who?
The office, High Court office.
No. The order only says about that order. Then
this is the IA only.
you file an IA.
I have filed an IA.
I will clarify that.
My lord. 2135. I was also confused.
Because the order is
that is
categorically clear. It is only IA.
IA is ordered.
You see why? If you see here, you actually don't get it in this certified copy because now I can order this file to this.
I have checked up.
You see this file transfer petition. It is only in the IA. The order is there. IA C1014 of
Obviously
2000.
telling that both the matters are disposed of.
No.
We are inquiring about the issuance of notice, Lord, because respondent number 6 is issued notice.
It's an application only.
That's only IA. That I have seen.
The instant heard Mr. D.P. Solia, the learned senior counsel, assisted by so and so, and Miss, you are appearing?
Yes, your lordship, for respondent number 1 to 3.
Respondent number 1. Full stop. The instant application has been filed seeking a clarification for recalling the order dated orders which were passed in TRPC 32/2023 and TRPC 68/2023. Order dated 10/5/2024 in TRPC 32/2023 and TRPC 68/2015. Full stop. This court duly asks inquired with Mr. D.P. Solia as regards the learned counsel, Mr. D.P. Solia, senior counsel, Mr. D.P. Solia, as to why the order needs to be recalled. The learned senior counsel submits that the office in the the registry of this court have understood that the order so passed on
In five.
10/5/2024 amounts to disposal of TRPC 32/2023 and TRPC 68/2015. This court have duly perused the records, and from the record it is seen that the order dated 10/5/2024 is only in relation to IAC number 1014/2023. And only that application, that is IAC number 1014/2023 has been withdrawn. Full stop. However, the TRPC number 32/2023 and TRPC 68/2015 shall remain pending till such orders are passed in accordance with law. So accordingly, the instant petition stands disposed. আর এইকিটা TRPC 32/2023 and TRPC এই ইয়াতো order হয়ে গেছে। They have put photocopies only. এইকিটা দিব, এই দুটাতে লিখি দিব, হ্যাঁ, TRPC 32/2000 TRPC list these matters before the appropriate court on দিব, হ্যাঁ, list this matter before the appropriate court on 2nd of September. Yes, what is this?
I'm telling you the order page 55, my lord.
Page?
55, my lord.
Yes.
Jurisdiction, my lord.
Huh?
It is without jurisdiction, my lord. The last date of issuance of this order was 30th of April, my lord. But it has been issued on 1st of May, my lord. The original date was, my lord.
So as per you, the last date is on 30/4/2024.
Yes, my lord. It page 54, my lord.
But it was issued on 1/5.
Notification lordship will found at page 54, my lord.
Yes.
Lordship, here I have not received any instruction.
Right.
I pray for a short time, Lordship.
Isn't it tax?
Yes.
The government doesn't want money. We assume that the government doesn't want money. Huh? How much?
Lordship, 10 days, Lordship, 10 days, Lordship.
Mr. B. Chaudhary, the counsel appearing on behalf of the respondent submits that within 10 days, the affidavit would be filed on behalf of the respondents. List the matter again on 19th of August 2024. The affidavit be filed by 12th of August 2024. The petitioner, if so advised, would be at liberty to file reply. Full stop. Interim order passed earlier shall continue till the next date. Yes.
So here, my lord, we have received the sworn affidavit, my lord, we are going to file it tomorrow. In fact, it is in the process of filing.
What? What has happened?
To file an affidavit, because the short point is whether the land of the petitioner is going to be acquired, my lord, for the purpose of the Tesco flyover project, essentially flyover project. This is the short point in the book.
Then?
This case has a checkered history, my lord. There was a separate writ petition earlier filed in 2022.
No, what is the short point?
So that
The
whether
short point is
filed
that
on-
he is having a flyover. It is not a point. It is a question of fact.
Only whether my land is going to be acquired. If they say that it is not being acquired, then the matter ends there.
So they are going to acquire your land.
That is what they have to clarify.
So if they acquire, you'll get the compensation.
No, that is, they have to file an affidavit as to whether they are intending to acquire. Because as
But what is your case?
my case is that what happened initially that in 2022, a general notice was published on part of my property and of various other people in that area, saying that there are certain encroachers of the government land and the land is required to be for the purpose of the flyover project. And that notice was assailed by a series of writ petitions. Status quo orders were granted, which continued up to 2024. On 19th of June of 2024, the previous writ petition was closed because they clarified in their affidavit that the petitioner's land under that Dag and Patta number, which we had mentioned in the previous writ petition, that they're not proceeding to acquire. They clarified that aspect of the matter. However, during the pendency of the petition, the circle officer conducted a survey of another part of the petitioner's adjacent property. But there are certain adjacent lands. So, we, after the observations of the, we filed this writ petition, and an interim order has been passed that no part of the petitioner's property will be demolished without the leave of the court.
Why?
If they say that we're not going to acquire any land, that matter in there, the process has to be.
No, they will take, you are going to acquire under what provision?
It is under the National Highways Act.
National Highways Act, they will acquire.
And clarify, then the matter will end there because they have to, there is no notification in my seeking the acquisition of land in my possession. Nothing as of.
No, if I go by the instructions, my lord, his basic prayer is that at page 21 of the writ petition. He says that he is in possession of a plot of land covered by Dag number 884 of periodic Patta number 350. Now, he alleges that the authorities are going to construct, my lord, the flyover by forcefully evicting him. My instruction says that, my lord, that this plot of land has not been acquired.
Has not been acquired.
No. So to that extent, I will file an affidavit. It is in the process of filing.
If they say an affidavit.
No. First and foremost, whether they will acquire or not.
Yes.
If they acquire, they will issue notice under 3A.
Yes. The crux of the question, because in the series that was pending earlier, in which I was also a writ petitioner, the issue arose from that general notice, which is there on record, 1st of July 2022. Because simply a general notice without naming any person, was pasted on the certain property, saying that there are some people who are government, who are the encroachers of government land, and you vacate that property.
You are not a government land.
No, I'm not on.
No. How does it matter?
That is why the apprehension arose. That is why the status quo orders were passed, which continued.
What status quo order? What status quo? How can there be a status quo order in this type of things?
In the earlier round of writ petition.
So now, extension of order will be considered upon hearing. Till the next day shall not carry out any demolition in the existing building without the leave of the court. Where is the question of building demolition?
No, in the earlier writ petition, what had happened, my lord, in the roadside reserve land, my lord, there is a highway going, and their petitioners have constructed business establishments out there. They have transgressed into the highway. This is where the matter lies. This dispute lies. Now, my lord, those writ petitions has been closed. We have clarified everything in the affidavit. And in 1 or 2 cases, my lord, it was found on affidavit that in
you have the instructions.
No, I have the instruction in this case. So therefore, I am just.
I close it.
Otherwise, the lordship permission, because the affidavit is in the process of filing.
Why do you need it?
We have already given it for filing. If lordship allows us, my lord, then next.
No, isn't it surprising if the government, yes, there is a mistrust with the government. Right? The mistrust maybe have some basis or whatever maybe, but the mistrust can't be to such an extent that you can file a petition that tomorrow they are going to demolish and they just say.
Lordship will kindly have page 62. That is the
Lordship will kindly.
If they do anything, they will take action in accordance with law. Matter over.
Now, if my lord fits, please,
Lordship will have it day after tomorrow or tomorrow. It will come on
I'm submitting, silence. But if lordship is fixing this matter either on Thursday or Friday, by that time the affidavit will be on record, lordship will dispose of it, madam.
Yes.
So it will be a statement on oath. I will fortify the, because in all other petitions we had filed affidavits, and on the strength of affidavits, my lord, they have withdrawn. It is not closed, they have withdrawn.
We have withdrawn the other petitions. We have withdrawn.
On the strength of the affidavit.
On the strength of the affidavit.
Isn't government. No, this type of orders being passed means
Yes,
encourages,
Yes.
because this will, it doesn't solve, you see, the basic trust upon the authorities has to be there. It can't be such that tomorrow, there is a law. If tomorrow builds any, demolishes his house, obviously he has a right to take action.
So therefore, my lord, all these lead petitions are, my lord, based merely on apprehensions.
These apprehensions can't be made.
That's only they have withdrawn, my lord. On the, once we have filed
If
our.
the arbitration appearing on behalf of the petitioner, respondent submits that the affidavit is, submits that the respondent authorities are not taking any steps for acquisition of any land of the petitioner. He, however, submits that the same would be put by way of an affidavit. List the matter again on
Friday, my lord. By
Friday,
that time, my lord, we will.
26/7/2034. The affidavit will be filed by tomorrow.
I'm so obliged.
Affidavit will be filed in the meantime.
Fine. Already in the process of filing, we had given it to the clerk again, my lord. I'm obliged.
Yeah, what is this?
If transitional credit was claimed by the petitioner by filing a Tran 1 form. But transitional credit, lordship, previously it was VAT regime. Then the GST regime came into from 1st of July 2017, lordship. The petitioner survived for 3 months in the new regime, July, August and September, lordship. But after those 3 months, lordship, his business got closed. His registration was cancelled by the GST authorities. But for the period before the setting into of GST Act, there is a provision to claim transitional credit of the stock in hand as on 30/6/2017, lordship. That transitional credit was claimed by the petitioner by filing a Tran 1 form. Now, as the business of the petitioner was closed, lordship, some so-called notice was issued by the respondent authorities, which was never received by the petitioner. What the petitioner was asked to do is, do you produce the invoices in support of your transitional credit so that we can allow the transitional credit to you? But since the business closed down and registration cancelled, the notice was not received. So that culminated into an order that Tran credit will not be granted to me, lordship. Against that order, I tried to file appeal, lordship. But they don't allow me to file the appeal. The GST portal doesn't allow me, saying that there are some earlier dues relating to July, August and September 2017. And first you have to pay those dues, only then you can pay the pre-deposit for appeal. But this, the GST portal only says, lordship, there is no such provision in the Act which says that first you satisfy the earlier dues or we will take your right of appeal away. So there can be twofold prayers which can be considered by your lordship. Either the matter can be remanded back to the original.
On 27/6/2024, SC Kyle submitted that he will take up, he would produce some instructions in that regard. Is not present. Hello, we direct the Commissioner CGST to appear in person. None appears on behalf of the CGST.
Otherwise, lordship, all the invoices have been enclosed with the writ petition.
No, we direct them to appear because you see the CGST is not represented. It's an important matter. They have not represented. Ask this person, the superintendent GST, to appear. None appears on behalf of the petitioner on call, on behalf of the standing counsel GST on call. When the matter has been taken up. It is seen that on 27/6/2024, the standing counsel of the GST had undertaken to place before this court certain certain notifications which have been issued, which provides that earlier dues will have to be cleared before an appeal is filed. However, as the counsel is not represented, this court is not in a position to further progress in the matter. Under such circumstances, this court fixes the matter again on 7th of August 2024. The Superintendent GST Central Excise Range Roman 2A GST Bhavan Kedarnagar shall be present through video conferencing link on it to the additional 7 on 7 through video conferencing link at 10:30 AM.
Highly of the Lordship.
My lord, in this case, we have filed our affidavit on. We have filed our affidavit in opposition for respondency on last Friday, my lord. And this is not on record. Let it be on record.
The respondent number 6?
Yes.
It's on record. You have something to say, Mr. Dutta?
I am for the petition.
You are going to file reply?
Yes.
The petitioner submits that the affidavit has been affidavit in opposition of the respondent number 6 have been duly received and would file and reply. Is the matter on 5th of August 2024. The affidavit reply be filed on or before 2nd of August.
Getting order.
Same order passed earlier shall continue till then. Yes, what are these?
Your Lordship, we only received our the affidavit last week on 17. Affidavit filed by respondent to only receive on last week, sir. So we need some time to file our reply.
Counsel appearing on behalf of the petitioner seeks for an accommodation to file reply to the affidavit in opposition filed by the respondents on 19/7/2024. It's the matter again on 19th of August 2024. Interim order passed earlier shall continue till then.
Lordship, as per the
Why the FAO before me?
court's order, last order, your lordship, we have furnished the affidavit.
Oh, that undertaking.
Yes, lordship.
If you honor kindly
With
peruse
copy to the other side.
paragraph 3 of the undertaking. Paragraph 3, lordship. They will demolish the construction. I'll have to file objection, lordship.
Why?
Lordship, your lordship knows very well the length of trial. This is our case is at the stage, very early stage. Then first appeal, then second appeal. They will possess till disposal of second appeal. They will demolish the construction.
Okay, you give an indemnity. You give an indemnity that in the circumstance you lose the case, you are to pay him everything. The loss which will occasion. Don't come up with all this. Yes, given an undertaking, that undertaking is suffice. Let him construct. He will demolish. That is an undertaking being given by him by filing an affidavit.
It wants to bring certain other condition, lordship. If you want,
If you want to, lordship, will surrender the land as well as the construction also, in his paper.
Huh?
In his paper.
If he wants your lordship, we'll surrender the land as well as the construction, your lordship, we are over to him, your lordship.
He said so.
Land plus building. We'll get,
He won't demolish, give you the building.
with building, you will get the land, your lordship.
This may proceed for next
There is
15,
no
20
question
years.
of, otherwise we
Very
are
well.
not getting any.
Trial court, first appellate court, second appellate court.
Yes, I'll be
It
with
may go to Supreme Court. It may go for execution. So this
I'll
is how
file
the civil courts happen. So how does it matter?
I'll file an objection against this undertaking, lordship, and
Let him
alternatively, I
carry
will
out
say
his construction.
to take up the matter on merit on next. fifth
No,
day, lordship.
we are. You want to file objection, whatever may be. That order which is there, where is the order? And he said that he's not going to create any third party rights.
Right, that is 27/6/2004. 27/6, last order.
So I may be allowed to bring other certain conditions, lordship, as per instruction of the authority. Kindly consider 4 or 5 days time
For what?
filing an affidavit.
Okay, I put order, how can you?
What affidavit you are going to file?
Yeah,
Not file of
the party wants to bring certain other conditions.
What other conditions?
Regarding taking any financial assistance from bank.
He said that he is not going to create any third party rights.
No, buildings should not be constructed, demolished. lordship. Buildings should not be demolished.
What?
Here,
Demolish and give it to you. You are only concerned with the land. That portion of the land.
I am concerned with land, but it's may take another 15, 20 years time.
It may take 100 years. So
Ultimately,
So it
my
is
party
your,
will lose
how,
all benefits.
how far you are in a position to proceed with the trial as soon as possible. That is your thing. Don't take adjournments.
So my party instruction is only construction should not be demolished. Construction should not be demolished after disposal of the.
Construction should not be demolished. This is- I have given the undertaking, your lordship. I will not demolish it. I will hand it over to you.
Here it is mentioned, I shall demolish any construction made during. the-
Yes, he is constructing, he will demolish it. Who are you to say? You on one hand have an objection for him to construct. And now you are going to say that construction should not be
My
demolished.
party was earning rupees 68,000 per month from tenant. Tenant took injunction order that was violated, and during pendency of my suit, they demolished all construction. Now monthly benefit. Gone, lordship. So after construction and possessing 15, 20 years,
How did you get a money decree in this suit?
Ask for money.
They will get a money decree in this suit.
Mr. Ali, Mr. Samran Ali, I am fixing, when did I fix the other matter, your other matter?
Trial
That
court.
day I heard it.
The trial court.
No, that matter with Mr. B.D. Deka, that second appeal,
Or 25th.
25th, no?
next week, lordship, kindly Tuesday. Next week, lordship.
25th or next Thursday, your lordship.
My party is senior citizen now under medical treatment.
Who?
My client. I is it about 70 years of age. So she needs 4 or 5 days time.
And did he file the reply?
Kindly fix next Tuesday also.
Did he file the affidavit?
2, 3 days before.
Mr. R. Ali, the legal counsel appearing on behalf of the petitioners, that he needs take instruction in the matter. This matter again on first of August 2024. liberty given to the petitioner, appellant to mention the matter for upgrading. First of matter, you mentioned it. I'm having it on Thursday. 1st of August. You mentioned the matter for upgrading.
Hold it. 93 order.
Wait, please, Lordship. In this matter, we
What
are
is this?
directed to file an affidavit, Lordship.
Where the petitioner is entitled to the amount of application which the court has directed to. Yes, they're entitled,
No, Lordship.
petitioner.
Lordship, we need some more time, Lordship.
I gave you on 19/6.
Yes, Lordship.
Then
1 minute time, Lordship.
you file contempt.
Lordship, no, because of the pendency, Lordship, we have not.
Okay, we make it clear, huh? That the pendency of the review shall not bar the respondent to initiate contempt proceedings. This court, by an order dated 19/6/2024, had sought for instructions from the petitioner, review petitioner, as to whether the petitioner is entitled to the amount of rupees 24,99,741. However, even after a passage of more than a month, no instruction has been provided. And the counsel appearing on behalf of the review petitioner seeks for time. Accordingly, list the matter again on 21st of August 2024. It's clear that the pendency of the review petition shall not be barred to the respondent to initiate contempt proceedings against the erring officials of the revenue.
Deeply obliged.
Obliged, Lordship.
List the matter again on 7th of August 2024.
Yeah, please, Your Lordship.
Yeah.
After liberty, I want to withdraw
The petition,
Yes.
what liberty?
Lord, this case was filed, my lord, because the State Bank of India hold up my salary account, my lord. After they unhold, my lord. They may in future, my lord, they may in future again hold up, my lord. That is why liberty I am praying for.
That will be a separate cause of action. Why liberty? Liberty is only for the same cause of action. They have already, they are no longer.
We filed one representation, my lord, because we want to repay my husband's due.
Now they are not withholding your salary account. The Mr. S. Dr. The counsel appearing on behalf of the petitioner submits that the instant with petition was filed on account of the State Bank of India withholding the salary account of the petitioner. He, however, submits that in the meantime, the salary account of the petitioner have been released, and as such, nothing further survives. The learned counsel submits that in that view of the matter, nothing survives in the instant writ petition. It is also submitted by the learned counsel that in the circumstance, at a subsequent, in a circumstance, the SBI again does so, liberty may be given. It is the opinion of the, in view of the above submission, the instant writ petition stands closed. It is the opinion of this court that if at a later point of time, the petitioner's account is again withheld, the same would constitute a separate cause of action and for which no liberty is required.
May I submit one more thing? I was supposed to withdraw in the mentioned hours in the morning, my lord. Therefore, I requested my colleague, my lord, the counsel for SBI, not to come to court, my lord. So, if possible, my lord, N. Borua, his name may be recorded, my lord, because on my request, he didn't come.
The N. Borua appears on behalf of the SBI.
Highly obliged.
Come on.